Good afternoon, everyone. Welcome to the Appellate Division First Department. We have about 7 hours of argument time scheduled for this afternoon, so please ask only for the time that you absolutely need to make your most important arguments. Bear in mind that we have the record, we have your briefs, and we're fully familiar with the facts of this case, of all of the cases. And if we feel that we need to hear more from you, we will be sure to allow you to continue to speak. Okay. People versus Déjeuner Canteen. Five, 1, and 5. O'Brien versus Tectonic Builders. 5, 2, and 5, thank you. Nyla D is submitted. Rivera versus Site 2 DSA owner. 5, 2, and 5, thank you. Serhant versus Federico. 5, 3, and 5, thank you. Musey, or Muse, I apologize, versus the City of New York. The City University of New York. 4, 1, and 3, thank you. People versus Edwin Ortiz. Submitted. ZDG LLC versus 310 Group. Are you the respondent? 5, 2, and 5, thank you. People versus Luis Perosa. Submitted. Aisha K. versus Philip C. I beg your pardon. There's no one else here. Do you want to argue or submit? Well, any questions from the bench? No. Submit? Okay. A few chuckles there. Who was chuckling? Somebody else want to submit? Okay, thank you. People versus Tara McDonald.
Good afternoon. Respondent requests 5 minutes.
6, 2, and 5. Thank you. Board of Managers versus Park Associates.
5 minutes for responding.
5, 2, and 5. Thank you. De Jesus Jimenez versus Rodriguez.
3 minutes, Your Honor. There's a case I'd like to discuss with you, a new case last week.
I beg your pardon? You asked for 3 minutes.
I did.
Okay.
There's no one else here, that's why I went right into that.
Oh, I see. Okay. 3 minutes and a submission. Do you wish to, you do not wish to submit, is what I think you're saying? Okay. 3 minutes and a submission. 538 Morgan Realty versus Law Office of Ahong Yu.
Good afternoon, Your Honor. For plaintiff appellant, we would request 6 minutes and 5 on the clock.
For respondents, the review defendants, 5 minutes.
For the Smargassi respondents, 5 minutes.
I'll give you 6 and 2, 5 and 5. Roth versus Board of Managers.
For appellants, 5 and 2, please.
Are the respondents here on this case? Do you want to submit? Submission, thank you. Health East Ambulatory versus Countrywide Insurance.
For appellant, 5 and 2, please.
5, 2, and 5, thank you. Deterring versus New York City Environmental?
Good afternoon, petitioner appellant, 5 and 3, please.
5, 3, and 5, thank you. Dettering, thank you. I hope I remember that for the next time I have to say it. People versus Huron Montgomery? Submitted. Badame, again, sorry if I mispronounced that, versus ACOM? Badami, thank you. 3, 2, and 5. Okay. I am going to call number 5 out of turn. We'll call that first. That's Serhant LLC versus Federico. Wait. Would one of the officers step up, please? It's not the right case.
Should I go to the microphone right there?
It is the right case. Okay, great, that's the right case. And just a minute before I begin, and also, numbers 2 and 19 will be called at the end of the calendar, okay? As one of the justices is recused from both of those cases.
Should I proceed? Proceed.
Just a minute, please. You may.
May it please the court, Michael Cole for the appellants. I'd also like to express my appreciation to the bench and to counsel for giving me the accommodation. Thank you very much.
Sure.
Aside from the argument in the briefs you've all seen about the prohibition against automatic renewal of brokerage, I'd like to show you from...
Just let me stop 1 minute. Could you see if you could reposition the microphone a bit so we can hear from...
I'm sorry. Any better? Better?
Yes.
What I had said was, aside from the prohibition against the automatic renewal of brokerage commission, automatic renewal of a brokerage agreement, which is illustrated in a brief, I'd like to augment that from the record that shows absolute no viability to the appellant's claim against the defendant brokers. I'd just like the court to look at record page 267, and there you'll find the letter of the General Counsel of Douglas Elliman sent to Serhant, February 15, 2022. You'll note that it makes the point there are no buyer exclusions. What does that mean? That means that the buyer Eichenholz, should he buy during the term of the Douglas Elliman exclusive, well then, the seller is liable. The buyer, the broker, Douglas Elliman, is not liable to Serhant for fulfilling the terms of his brokerage agreement. In fact, what that really means is in the event, and putting all the automatic renewal aside, if Serhant did have a claim, it would simply have a claim against the seller. It doesn't express a claim against the other broker. For example, see paragraph 20 of the complaint at record page 79. There is the admission that the only thing that Serhant asks of the defendants is an amicable resolution that maybe they should take care of the Serhant broker. But that does not create a legal obligation. Being uncontested fact.
Well, counsel, though, I mean, the claim is not for a breach of contract, right? It's tortious interference with contract.
Correct.
So that, regardless of whether there was a claim between the two brokers for a contract, what the broker is saying is that the Douglas Elliman firm knew about the contract with Serhant, caused Serhant caused the client to breach the contract, and Serhant is damaged. That's the claim. It's not a direct claim between the two brokers. No one's, I don't, that was not what judgment was entered on. Judgment was entered on the tortious interference claim, so that, I think, is what you need to focus on.
Let me focus on tortious interference right now. Let me skip right to it. Give me a second. In the decision appealed, the court below says in December of 2021, the Douglas Elliman broker interfered with the contract of Serhant, knew about it, interfered with it. That comes from record and deposition pages 154 to 1.
Well, what part of those prongs are you saying wasn't met here? There's no doubt that Douglas Elliman knew about Serhant's contract. There's no doubt that there's damages because Serhant didn't get the money that it says it's entitled to. So what are you claiming hasn't been met?
Well, two things. First of all, there are no damages because there's no liability from Douglas Elliman to the broker, Serhant. But beside that, let me tell you what is actually said in that deposition about what happened in December of 2022. It's memorialized and it's plain, and it says this is what occurred. In December of 2022, as the Serhant brokerage agreement was expiring, a mutual friend contacted the broker, Rubin, and asked him to come down and look at the property.
No, I mean, we know what the record says, right? But what are you saying didn't happen? You're saying that there wasn't a procurement of the breach?
Correct. None whatever. He never said to Douglas, he not only didn't procure the breach, when Douglas Elliman signed its brokerage agreement, it was after the expiration of the Serhant agreement. And he never said, use us while your brokerage agreement's still in effect. He merely said, get back to me when you have and are ready. In January of 2022, he got back to him. And at that time, he showed Douglas Elliman broker the agreement that he had with Serhant.
Okay, thank
And
you.
that agreement,
Sorry. I thought you were done with your sentence. Go ahead, finish. And that agreement?
he said, had an original term of 180 days. And as his understanding, it was either expired or expiring. When the agreement was signed with Douglas Elliman, it was clearly after expiration. So there was no breach induced because no breach occurred, even if you put aside all the other arguments. There just isn't a breach. And the damages...
Thank you. You can continue on rebuttal, okay? We'll hear from you again then.
Thank you.
He's going, yeah, okay, great, thank you. Thank you.
Good afternoon, Your Honors, and may it please the Court. Dean Boyer, Lester Shaw, and Levy on behalf of the plaintiff respondent, Serhant LLC.
So can I ask you the question that counsel is telling? What's evidence of of intentional procurement of the breach?
Well, first of all, Mr. Rubin acknowledged that he received the
No,
continuation
I think counsel
agreement.
agreed with that he agreed that there's a contract, but what counsel is arguing is there was no intentional procurement of the breach. So what evidence did you put in to show that there was?
Both Mr. Federico and the purchaser, Mr. Eichenholz, acknowledged that the offer was made through Mr. McPeak at Serhant, and that he was owed a commission based on the 90-day extension letter as one of the names who was listed on that letter. And Mr. Rubin came back and said, and Douglas Elliman came back and said, no, you're not owed this. That's incorrect. They were clearly owed. They intentionally procured the breach by inducing him to sign this eventual contract of sale, which was within that 90-day window, naming Douglas Elliman, not Sirhant, as the broker on the sale.
So there's no dispute that they were the link to the purchaser no dispute at all?
None whatsoever, nor was there any evidence offered to the contrary in the lower court, which, overarching the argument is the question that the counsel is trying to raise is an issue of fact that was not addressed in the lower court. Counsel focused his entire argument below on the applicability of two provisions, which he claimed invalidate the extension agreement or the automatic renewal provision.
So it does say in the NYCRR provision that these agreements are not supposed to have an automatic renewal. So why does that not invalidate the contract?
That question is really irrelevant to the issue here before the court today, which is whether there's whether there's a claim against Douglas Elliman and Mr. Rubin. As non-parties to the agreement, the case law in this department is very clear that they don't have the authority or they don't have standing.
Well, I mean, I think
call
that,
that into
I
question.
wouldn't say that that's correct because they are a beneficiary of the contract, so you can definitely have some rights under it on a third-party beneficiary. The question is, what is the meaning of NYCRR, that section? If it says a broker can't enter into the agreement, what is the effect of that? Does it mean the agreement is no good, or does it mean that the broker is going to get punished for doing something like that?
Well, I don't know that they are third-party beneficiaries of the.
Okay, let's assume that let's put that aside. Okay. What is the effect of that provision?
I would say that the effect of that provision is, the way it's worded is that it cannot be extended beyond the termination date. And again, this is the 90-day period we're discussing following the termination date. The Sunset case from the Queen's Court, which is cited in our briefs.
Yeah, but that's not about an automatic renewal, so that's not really quite relevant, is it? This is a case where you did it where the contract has exactly what the NYCRR says a broker may not enter into. But then the question becomes, what effect does that have? Just because the broker can't do it, what effect does that have on the contract itself?
Well, again, the argument that it vitiates the contract or that it somehow voids the contract is not for the defendants to make in this case. And
well, that's what they said. They said if you can't procure a breach of a contract if there's no contract. Right? Well, that's pretty straightforward. So again, I'm going to ask you, what is the effect of that provision on the contracted issue?
Well, let's say that it prevents the renewal period from existing, right? That means that the contract, by all accounts, ended on January 29th. The extension agreement, which we agree is still outside of that and not included in that, that extension agreement would still carry us to, I'm not going to do the math in my head, but there's clearly interference with the contract within that 90-day period. Even
You're talking
from
about the survival
April 100.
period. You're saying the statute
yes,
doesn't
and it says Eichenholz
render that
named on
insignificant.
list. Exactly. That survival period still survives, for lack of a better term, and that survival period is what was violated. Not only that, Mr. Federico, the buyer, acknowledged when Mr. Mr. McPeak, the Sirhant broker, sent him the list, and he said, remember, if it's sold to anybody on this list within 90 days, we get the commission as per our agreement. The seller, Mr. Federico, responded immediately, I acknowledge this. There's no question, again, that the person who was a party to the contract agreed that he was bound by this, and it's not for, again, Douglas Elliman and Mr. Rubin to come in and say, that invalidates the entire thing, you never had a contract. The parties to that agreement clearly agreed that that agreement was binding because it was, and it was violated at the behest of Douglas Elliman and Mr. Rubin.
What is the effect of signing the contract so many months later?
Excuse me?
What is the effect of the fact that they didn't actually go to contract until so many months later?
What do you mean by go to contract?
The actual signing of the contract didn't take place until May of 2022.
Well, again, that was within 90 days of the termination of the contract under the renewal period. The signing of the contract of sale was May 25th of 2022. Is that what you're referring to, Your Honor?
Yeah.
Yes, again, that was within the survival period if we're tacking on the 1-month renewal. But even if it was not, we have, again, a letter from Mr. Eichenholz, the eventual purchaser, who said, were it not for you interfering with this contract, this would have already closed, right? And then you can establish an element of tortious interference. It doesn't have to be actual breach. It can show tortious interference rendering performance impossible, which is what he did. He essentially made it so that they ran the clock out and didn't get to sign it within that period.
That's
Thank
what
you.
I was getting at.
Thank you, Your Honors.
Just a moment, we're going to get you back at the podium.
Can you hear me? Can you hear me?
Yes.
Thank you, Chief Cavallo.
I can answer that. First of all, the May 25th date that you see on that contract is not the date the contract actually became binding. Look to, let me give you the record site on this. This is contract 1.22. In 1.22 of the contract, it says that there should be an extension of 30 days additional to allow the buyer to obtain $2,350,000 in financing. The affidavit of Rubin tells you that the Compass broker could not do that. It tells you that he obtained financing through First Republic Bank. Then there's the fact that the contract of sale signed by buyer and seller specifically states that the procuring brokers were Douglas Elliman and Compass. There's no mention whatsoever of Sirhan being the procuring broker. So it's not 90 days, it's 90 days plus 30 on May 25th, and the deal was saved by the Douglas Elliman broker. And moreover, I would add, when offers were being made in March of 2022, that was during the exclusive period of Douglas Elliman. I could argue that, although no damages, the tortious interference occurred from Sirhan. He shouldn't have been making offers after the Douglas Elliman exclusive was in effect. Moreover, it's not enough to make an offer. You've got to close the material terms of the deal. The Sirhan broker only made offers. He did not close the deal. He did not obtain the financing. He went past the 90 days. He is in violation, if not just the general obligations law, but the requirements of brokerage statute, which plainly says you can't automatically renew, which they did.
Thank you. Thank you both.
Thank you, counsel.
Rivera versus Site 2 DSA owner. Oh, I'm sorry. People versus Déjeuner Canteen. I apologize.
Good afternoon. May it please the court. Legal Aid Society by Everett Hopkins for Mr. Canteen. Your Honors, this court should reduce Mr. Canteen's sentence in light of his horrific childhood trauma, which has really directly caused his mental health and substance abuse issues. This court should also consider his sincere remorse for stealing his sunglasses in furtherance of his overwhelming desire to self-medicate.
So his sentence was only 1 year over the minimum, which was 5 years.
Correct.
Why was that excessive?
Well, it's excessive because basically every day Mr. Canteen remains incarcerated is over the minimum is excessive given these mitigating factors, which are extraordinary.
And what has he done in the time that he's been incarcerated? that shows that he's rehabilitated sufficiently
Well,
to be released a year early?
my understanding, and I've had some conversations, obviously this is not part of the record, but I've had some conversations with his
Well, if it's
social
not
worker.
part of the record, then it's towards the record, I can't hear it.
Okay, well, I was just trying to answer Your Honor's question as to
I
what
see.
he's done.
What's in the record that
Well, what's
says what
in the
he has
record-
done?
Sure, Your Honors. What he has done is based on Dr. Arroyo's report, which shows that there is a chance that he can be rehabilitated with a proper environment. Dr. Arroyo points to specifically if he's in a good therapeutic setting that has support for his mental health and substance abuse struggles, he has shown that his symptoms tend to dissipate. Now, while his neurological issues may not, fully recover, he is able to cope and live a somewhat normal, healthy lifestyle as long as he's in an appropriate residential treatment setting.
What happens with, what's to continue him maintaining his medication and everything else? Obviously, if he does that, it sounds like he's fine.
Right.
But how long has he been in at this point?
He's been in for about 5 years. 5 years will make November, so next month.
And the doctor is referring to a period of time that's how long?
How long he was stable?
Exactly.
It's unclear from the record, but Dr. Arroyo has been working with him for several years. So I'm sure he has more knowledge as to how long he was stable then. But what's clear is that he's not getting all that he needs while he's incarcerated. So I understand Your Honor's concern as to whether he can be rehabilitated. The answer is yes, based on Dr. Arroyo's report.
Can I ask you, how old is the defendant?
He's 36 years old now.
And he's had mental health issues for a long period of time, correct?
Since the sexual abuse started, which is around 5 years old. That's correct.
And he has not consistently sought mental health treatment for that period of time, has he?
Yes and no.
It didn't seem, that's what I meant, because to me, it didn't seem like he had consistently sought mental health treatment. He's not a young man, he's in his mid-30s.
Right, I mean, but the reason why your question is difficult is because he sought help in his teenage years at a young age. And every time he sought help from people, it just led to more trauma and more abuse. And so by the time he had fled that abuse from South Carolina and came up here to New York, he was around 20, 21 years old. He had already had a long-time habit of self-medicating because that was his only way of coping. So to say he hasn't sought help at that point, really, it's almost unfair to him because he doesn't know anything.
There are a lot, I could not agree more, a lot of things in his life are unfair to him.
Right. So that's the issue, right? And I go through at length. Obviously, you've read the briefs at length of all the horrific things that this person has faced. Not to mention he's a transgender man incarcerated without gender affirming care. So all of these things exponentially increase his risk to exposure of more abuse and more psychological harm. Briefly, Your Honors, with regards to the waiver of appeal, obviously, based on his mental health issues, I would argue that the court's colloquy was not clear in differentiating his forfeited rights from his appellate rights.
You mean those that he was giving up the right to a claim about most kinds of errors, which
Correct.
didn't clarify which, and then giving up some rights on appeal,
Right, and it doesn't.
which seems like that might be inconsistent, even though it might have been referring to the same thing.
It could have been, but again, it's not clear. That's the problem. And especially given Mr. Canteen's psychiatric history, it was incredibly critical that the court make sure that he understood everything about the waiver of appeal. So,
Thank you.
thank you.
Good afternoon, Your Honors, and may it please the court. Stacey Nadell for the people. Defendant's excessive sentence claim is foreclosed by his valid waiver of appeal. The court here went through a very thorough colloquy first.
Is it thorough and not at all vague or inconsistent when the court talks, I think, about one issue that he would be waiving, but then lumps everything together and says giving up the right to a claim about most kinds of errors, and then another time says giving up some rights on appeal. Is that clear?
In the
And
totality,
then adding to that, I'm sorry, but then adding to that what your opposing counsel has indicated, is there nothing additional that a court is required to do when a person before them comes with a history of mental illness or something that might cause them not to be completely clear?
totally understand, Your Honor. In the totality of what occurred here, the waiver was thorough. It was adequate for the circumstances that were there. So, in addition to the oral colloquy, there was a written waiver of appeal, which carefully went through the specific rights that would survive the waiver. So that clarifies in the oral colloquy where the judge said you normally would have the right to appeal. As part of your plea agreement, you are giving up challenging most kinds of errors, including, which is the exact claim raised on this appeal, the excessive sentence claim. And the court continued in that oral colloquy and said, you can still appeal, you will be appointed counsel.
How is this any different than what this judge might have done for another defendant? I mean, what in here acknowledges that there's some issue with mental stability or something that this defendant was facing that may be a different colloquy? This just seems like the one for everyone.
Perhaps there's not anything that's explicitly geared towards a defendant with mental health issues or challenges, but the judge here, first and foremost, really was explicit in separating the trial rights discussion from the appellate rights discussion and confirming the defendant's understanding after everything that was discussed, starting with the trial rights. The judge asked the defendant if he understood. After the appellate rights, the judge asked the defendant if he understood. He factually allocated to his crimes. He was represented by counsel. He had this detailed written waiver of appeal form, which he said he understood and which he signed through counsel. So in the totality of the circumstances, it's clear that this defendant understood what was going on. In fact, at the beginning of the colloquy, he said that he was compliant with his medication and knew exactly what was going on. So the judge perhaps wasn't concerned with this defendant's ability to understand because he had made it clear.
Counsel, let's say that we find that the waiver is invalid. Is the sentence that he received excessive?
The sentence is not excessive,
Why
Your
not?
Honor. Well, at the outset, this plea bargain was beneficial for the defendant. As a predicate felony offender, he was initially facing 8 to 25 years for robbery in the first degree. This plea agreement allowed him to plead to attempted robbery in the first degree, which reduced his sentencing exposure to 5 to 15 years. So 5 being the minimum, he received 1 more year than the minimum, which is not excessive in light of the fact that the defendant pulled a knife, stole sunglasses from a street vendor, then pulled a knife or another sharp object on him and threatened his life if he had called the police.
Was it a knife or a sharp object? I don't know.
My mistake, Your Honor.
But in any case,
It was a weapon.
was 5 years. He's already done 5 years. That's more than a substantial amount of his 6-year sentence. I'm not sure why it was 1 year over the minimum. The court didn't make that clear. But in any case, the argument is that he is at a point where it's sort of diminishing returns, I guess. He would be receiving better treatment if he were not incarcerated, where he had an opportunity to be in a community setting with more services. Is that not reasonable? Is that not something the people can agree to?
It's certainly a reasonable argument. The people's argument is that the sentencing court was aware of the mitigating factors that defendant now poses on appeal.
Well, these are different factors.
But let me, and also, but let me make, I want to make, for my own edification, this is not his first felony offense, right?
Correct.
So the minimum sentence, this was just above the minimum sentence, 1 year above the minimum for a second felony offender, right?
Correct.
And he also had
But
an open...
the term here was 5 years for a second felony offender. It's not like this was for a first felony offender. The amount is calculated, and it was calculated based on. So that was taken into consideration when the judge saw the 5 years, right?
Yes, that's correct. I think it's also important to note that The defendant committed this crime while charges were pending against him in Staten Island also for an attempted robbery in the first degree, and on that sentence, he received the minimum of 5 years. And here he just received 1 year above the minimum, which, given the fact that this crime was committed while those charges were pending, 1 year is not excessive in that sense.
So
And was this case run concurrent? Was it?
It
Did
was
they
run
run it
concurrently, yes, Your
concurrent?
Honor.
I was just saying there was an escalating amount of crime at that time. It was escalating.
Yes, he had several misdemeanor convictions, and then it went from robbery convictions to burglary convictions and attempted robbery, and with the weapon as well. The people believe that the 6-year sentence for this crime is appropriate. And if there are no further questions, we ask that you affirm.
Thank you.
Just briefly, Your Honor, 2 things. First, Mr. Canteen is not some hardened criminal. As you heard, most of his charges are about
Yes,
theft.
most hardened criminals don't take sunglasses,
It's about, it's, most of his.
but he did then show a weapon of some
Correct.
sort.
But what we have is a record of theft. Why theft? Because he has to self-medicate. It all stems back to his trauma of his childhood. With regards to the waiver, Your Honors, counsel did make a reference to the fact that the court continued to ask Mr. Canteen if he understood, and he said yes, and he said yes over and over again. There was one point in the colloquy, I'm not sure of the page, but where defense counsel does have to step in and slow Mr. Canteen down because he's actually answering before the judge finishes the question. So there is some evidence there that Mr. Canteen is just trying to get through this. He may not be really understanding the nature and the consequence of the waiver. And additionally, with regards to the written waiver, there's nothing in the colloquy that points to the written waiver at all. If there wasn't a written waiver in the record, we wouldn't even know that there was one at all because the court doesn't ask Mr. Canteen if he read it or if he understood it. And defense counsel was the one that signed it on his behalf.
Counsel, I'll ask you the same question that I asked your colleague. Why is this sentence excessive when he has an open matter pending in Staten Island, which is another robbery? He has been sentenced to 5 years on that robbery, and the court here decides to sentence him to 6 years concurrent when they could have sentenced him to consecutive time.
Well, because of the mitigating factors that I just mentioned, Your Honors. And
Weren't those mitigating factors considered when the court decided to sentence him to concurrent time as opposed to consecutive time?
It's unclear if the court actually considered them, but whether the court did or didn't, this court has absolute authority to reduce a sentence based on those factors, regardless of whether the court considered it or not. The Court of Appeals was clear on that in People v. Brisbane, and I believe People v. Ba.
And I don't think the treatment that he received was something that was taken into consideration then, because it only has happened within the last 5 years, from what you've indicated.
Right, that's correct, Your Honors. Yes.
Thank you. Thank you
you.
both. Rivera versus Site 2 DSA. Just a moment, please.
Hello, good afternoon, Your Honors.
Just a moment.
Sorry.
Okay, thank you.
Good afternoon. Lori Parkman for the plaintiff appellant. As you know, this is a labor law case where the plaintiff and 4 coworkers were hoisting an extremely heavy 400 to 600 pound gang box into a truck bed, 3 to 4 feet. There was no protection provided, even though every other time they had loaded or unloaded these heavy gang boxes, a hydraulic lift had been provided.
So even for this company, you're saying in this instance, when this company and these individuals had hoisted this gang box, they were provided with an actual hoist?
Yes, plaintiff's testimony was that every other time they have done it, that's on page 118 of the record, every other time they've been provided with a hydraulic lift. This time they were not. There was no safety equipment provided.
Definitely, there's no question that there was no safety device here. There were 4 people lifting this hoist, and it, I think, dropped 3 to 4 inches, and it was 400 to 600 pounds, or 4 to 5 inches, I think it dropped, and it was 400 to 600 pounds. And he rested it, the plaintiff rested it on his thigh for 2 to 3 seconds. Is that sufficient? Are those sufficient facts to fall under, let's say, a runner theory?
Yes, Your Honor. The risk here was an extremely heavy object falling 3 to 4 feet. The fact that it only fell.
I don't think it fell 3 to 4
It
feet.
didn't actually fall because
3 to 4 inches, or 4 to 5 inches is what he testifies.
plaintiff stopped it from falling 3 to 4
Exactly.
feet. He didn't rest it. He braced it for a couple of seconds. His testimony, my colleagues like to say it shifted, but no, the testimony was that he did this in order to prevent it from falling all the way to the ground and crushing him. So his injuries were a result of the risk of this unsecured object falling the 3 to 4 feet. And it doesn't matter that it only fell a couple of inches and didn't fall all the way to the ground.
Isn't it also true that Mr. Kenny, who worked for T.G. Nickel, who I think might have been the general contractor?
Yes.
Didn't he say that it probably would have been safer to use a lift gate, to use some kind of a protective device? They'd use a lift gate or something rather than lift it the way they were lifting it at that particular time when he testified.
He did, at 5:28 of the record. He said it would be safer, and that's how it was always done, except for this one time. And the case law, the recent case law after Runner makes it clear that the heavy weight that has to be considered, and the force that the object puts down. And cases such as Alley from this court show that even when it falls just a tiny bit, when it was in the process of being hoisted or lowered numerous feet and it was this heavy, that is the risk that the hoisting equipment is meant to protect from. The fact that the plaintiff was able to stop an even more catastrophic event, if the gang box had fallen, if he was unable to brace it with his leg and suffer the injuries, it clearly would have fallen within 240 sub 1. And his injuries were from the exact same force of it falling. The hoisting equipment should have been provided, and it's clear that his injuries are a result of not providing the hoisting equipment for hoisting this heavy gang box. Under the precedent of the Court of Appeals in this court, it falls squarely within 240 sub 1. If Your Honors, if I should quickly, the Supreme
You have
Court.
just a few minutes. You want to finish it up on, if you can continue if you like.
Oh, I just wanted to, the Supreme Court dismissed granted summary judgment dismissing the entire complaint. Plaintiff contends it's clear that plaintiff was entitled to summary judgment on the 241, but we also, just very quickly, think that Nichols, which was the general contractor, construction manager, was not entitled to summary judgment on the common law negligence and 200 claims. They didn't submit the relevant contract with the owner, which we submitted, and it shows that they had responsibility for supervision and providing the hoisting equipment.
Thank you. You can finish that argument on rebuttal, okay?
Right.
Thank you.
Thank you.
May it please the court, Nicholas Calabria with the law firm of Omni Demirs McManus for the respondents in this matter.
So, counsel, this is a huge box, gang box, 400 to 500 pounds. You just heard counsel give the facts. How does this not fall under our line of cases with regard to Runner?
Well, I will point out in the record that both the appellant and the respondent cite one page in the record, page 121, that describes what actually happened in this case. There is no 4 or 5 or 3 or 4 inch fall of this gang box. There were 4 gentlemen picking it up, and there's another one on the back of a truck. The testimony is they got the front wheels of this gang box on the truck, and at that point, one of them lost their grip. At that point, it slipped out of the coworker's hands, and the plaintiff said, I had to brace it. I basically
What does that
braced it.
mean? I had to brace it.
He put his leg up against it. So something's there, you're holding something, it starts to.
Counsel.
Let's go.
What happened if he didn't put his leg there?
Oh, if the other three people walked away and let him hold it,
No,
it
no,
would've came
not
down.
the other three people. One person
I
out of
don't-
the group that were used to lift this
Correct.
couldn't have been lifted by one person
No.
or two persons. That's why they were the number that were there. And that didn't work when one of them lost his grip. So it began to fall. What should he do? Let it fall on his foot? There was no hoist or anything else to assist.
No, what he should
No
do is,
safety device
what he should do is he should brace it. He'd have to put a little more force into holding it. It could have fallen, I agree. Hypothetical, it could have fallen.
So he braced it,
But it
and he
did
said he
not.
was injured from bracing it.
Well, the testimony is that he held it for 2 or 3 seconds. It did not fall. There's no 4 or 5
Lucky
inches.
for him.
There's no 4 or 5 inches anywhere in the record. It's in their brief, but it's not in the record.
Well, what about the testimony from Mr. Kenny, who worked for TG Nickel, which I mentioned to your colleague when I asked a question, who said that generally it would have been safer to use a lift gate or a box truck, something to help
Right,
lift this, and that was generally done, but not this particular time?
And yeah, that was the plaintiff's testimony. He and his coworkers.
That was I thought that was Mr. Nichols,
Yeah,
Mr.
that's what
Kenny's
Miss-
testimony.
Yes, that's what he said, but it was the choice by the plaintiff and his coworkers to not use one of their trucks with the hydraulic. That's what they had used. The testimony was in the past, they would come with a hydraulic lift gate, put it on the lift gate would rise, and they'd roll it off. In this scenario, that for some reason, they were putting it on a pickup truck, and they just pulled down the gate, and 5 of them, 1 on the truck and 4 lifting it. But again, it did not fall in any way.
How do you distinguish this case and this kind of injury from the other cases, like Colbeck, for example, where there was a plaintiff who was trying to prevent a chain block from falling and he injured his back?
Because in those scenarios, there was a fall, a significant elevation differential, and in this case, there was none. He held the weight for 2 or 3 seconds. They then put the gang box on the truck. The plaintiff said he wasn't hurt. He never made any complaints.
Well, we're here because he did say he was hurt. He didn't say it immediately, but he said it the next day.
The next day, he said it. And he said it must have been from that act. But there was no immediate incident where anyone took a report, where there were any complaints made, where he sought any medical attention. It wasn't until the next day.
Why don't we switch to Labor Law 200?
Okay, on the
What's your argument
200
with
cause of action, I think the testimony is clear that general supervision was definitely in the GC, but they had no role actually controlling and supervising this work. The plaintiff's employer was completely responsible for getting tools and equipment into and out of the work site, and that's where this work occurred, and there was no actual supervision of that work whatsoever, and therefore the labor law section 200 should have been dismissed correctly, and I believe so was the 240. Again, this will be the first case that I'm aware of where people lifting something that doesn't fall at all, not a few inches, not
I
a,
don't think that's right. I think the testimony was it did slip a little bit, and because it's 500 pounds as opposed to 10 pounds, slipping a little bit makes a big difference. You know what I'm saying? If it's a small thing that slips 2 inches, okay, but a 500-pound gang box that slips even 2 or 3 inches could really wrench someone's back.
I guess it really could, but the testimony still is not there. I will again direct you to page 121. There is no testimony about this for any elevation differential from the time there.
Isn't there testimony that his coworker lost the grip?
Yes, he lost his grip. So it got heavier, I agree. But there is no testimony in this record that it moved anywhere. They had 2 wheels up on the back of the truck. One guy loses his grip, and he says he has to support it, and he does it. but it doesn't, there's no testimony that it fell. So we're going to be going
I
into
don't
a
understand, how does it get from the position it's in to his thigh if it doesn't fall
It's the
after the person let it go?
It's the gait of a pickup truck. Your knee is, that's
He wasn't bracing it with his knee before the person let go.
100% correct, Your Honor.
Yes,
He was
so
not.
then it went from wherever the person was bracing it to his knee.
No, his knee could have came to it.
I see, okay.
I mean, there is no
I
testimony of it
understand.
falling.
Thank you very much.
Just a couple of points, to jump on the last part. It was clearly in the process of falling, and the testimony was the only reason it did not fall and crush him was because he braced it.
So can you point us directly to the record where he says it slipped at least a couple of inches, 4 or 5 inches?
His testimony does not
So where
state
does that
exactly
come from?
inches. He says it started to fall. It's page 121 of the record.
So how do we get to the argument that it slipped a few inches, if there's no fact testimony for that?
It's the force of the heavy object and gravity. It was in the process of falling, and he braced it. If he had not braced it, it would have fallen and crushed.
What
you
exactly, yeah.
Let me ask you, are you referring to the testimony on page 121? That's it. I guess Jamal had lost grip of it, slipped out of his hand, so I had to brace it. I basically braced it on my leg, my right leg.
And then later on that page, he says he did that to stop it because otherwise it would have fallen and crushed him.
Does he, well, that's what my colleague is asking. Where does he then say the distance it fell, for example, or?
That's what, he did not say how many inches, he just said it was in the process of falling. And here, it has to be remembered that the risk that they had to provide for to protect the workers from was it falling the 4 feet. And numerous cases say that the protection has to be provided.
But there has to be some gravity-related.
Yes, and his,
So where, that's what I keep asking you. Where does it say that this was gravity-related? Not just that he pushed his body against it, which wouldn't be gravity-related.
It seems like there have been some reference on page 130 of the plaintiff's, which was part of the plaintiff's testimony, where he indicated that the gang bucks had fallen 4 or 5 inches before it landed on his leg. Did he say that during, at page
Where did
130 of
that
his deposition,
come from?
Or
I
am I making that up?
don't have the exact site for you.
Well, the
what
record,
is
page
clear-
130.
I'm
Do you
sorry?
have the record before you at page 130?
I do not have the entire record, no. But what is, it's the force of gravity.
I think
is-
we understand that aspect. I'm sure we do.
What about
It's more the question of
so-
the,
what about counsel's argument that they had used elevation on the back of the truck in the past, and that these workers decided not to use that mechanism this time?
I thank you. I wanted to reference that. The statute is very clear that the defendants have the obligation to provide the proper safety equipment. Workers are not required to request the proper safety equipment. The defendants are required
there's
to
no issue
provide it.
here that the proper safety equipment was not used.
I'm sorry?
There is no issue, there's no question here that the proper
Exactly.
safety equipment wasn't used.
Exactly, and that was the cause of his injuries, which were from the force of the gravity when it started to fall.
The only questions were with regard to where in the record the plaintiff indicated the distance or that it fell, that the object fell. I think we understand your
Yes.
argument,
Okay.
both of you. Thank you very much.
Thank you.
Musey versus the City of New York. I apologize if I didn't say that properly.
Good morning, Your Honors. May it please the court.
Good morning, if you just, well, good afternoon, thank you.
Good afternoon, Your Honors. May it please
morning.
the court. I'm so used to the other department there earlier.
Yeah, just a moment, please.
Shall I proceed?
Yes.
The matter of Muse is of interest in that Mr. Muse was a permanent civil servant. And this, for many, many years, was not very exciting in the courts. But all of a sudden, with current events, it has become far more front page. But with respect to this particular issue, the
So
court
how is
got it wrong.
Mr. Yes, so the court below dismissed Mr. Muse's Article 78 proceeding.
Pre-answer.
Yes, pre-answer, that's the significant part. What is the issue here? What is the issue of fact here?
We believe the court got three things wrong. One, the court found that the date that the Article 78 filed was untimely. It's 4 months,
Okay,
not
beyond
120
that,
days.
it
Beyond
was
that,
timely.
there really is no evidence below in the record. The hearing officer found, from wherever the hearing officer found, that Mr. Muse participated in the advertising of this course. Everybody took issue with the course.
But
and they
that's,
found-
may I interrupt you? That's a legal issue. That's a finding, right? No one disagrees that everything that was in the record is in the record. There aren't any fact issues about what happened. The issues are what the hearing officer found from what happened, correct? You're not saying that you are alleging a fact that the city university is disagreeing with, are you?
Well, there is disagreement.
About what? What fact?
One, Arthur Klock had no qualification to testify about what a non-union applicant for this certificate had. He never processed a non-union application. Two, Manny Troyce testified that the city approved this advertising.
Right, but okay, and
the city never produced.
May I interrupt you again? The
No,
city university doesn't dispute that that's what he testified to, correct? They just didn't believe, they didn't accept that, the hearing officer didn't accept that testimony, right?
The city university had possession of the person who approved it. That was their employee. They could have produced him and said, no, I never approved that.
That person didn't testify.
Never showed up. Many people never testified. There were many relevant parties that should have testified on behalf of the City University of New York. The only people who testified were Arthur Klock, who really did not have knowledge, and a clerk in the office that went on about how all of this money went to Mr. Muse or whatever, which in fact was not the issue. And the Attorney General's investigative report said it wasn't, the money was as per CUNY.
In fact, that was, I believe, one of the charges that was dismissed.
And it had to be dismissed, and really kind of slyly dismissed, in that the City University had an investigator's report that said there was no financial impropriety, and yet having that report, they drew up charges saying Mr. Muse stole hundreds of thousands of dollars, which was not the case. He was a teacher, approved to teach.
And so those are among the facts that you're saying are inconsistent, or that those are the facts that you're saying are raised here that weren't able to be addressed, that were not able to be addressed when this was dismissed?
Quibbling about facts at the appellate division is not getting me anywhere. The issue is that there was no evidence to support that Mr. Muse participated in the advertising. He did not create the advertising. He did not circulate the advertising. He was merely an employee teaching this class.
So your beef is with the finding, not the finding of the hearing officer. You're saying that the hearing officer's finding was arbitrary and capricious.
And without evidence below. Yes, Your Honor.
Okay.
Absolutely.
And we're only talking about one charge. We're talking about the charge of the misleading statement in the flyer. That was all he was brought up on.
The only charge that he was found,
Right.
and the basis of his termination, the termination of a 20-year permanent civil service he was a good plumber.
So I want to just be clear. Are you saying that there are facts that were not considered here? In other words, that it shouldn't have been dismissed at the stage it was because there were facts that were not yet developed?
Yes, they never answered. City never answered below.
I know they never answered, but it was dismissed because the court said that there were no issues here. Are you saying that there were issues that should have been addressed? Issues that raise fact issues here?
Yes, Your Honor.
And what were those? That's what I'm
The issue of
Because you
the
just
absence of
told
evidence.
Justice Scarpula that there weren't any, that it was arbitrary and capricious, but there were no facts that were at issue.
Below at the hearing level in the administration. At the trial, yes, they really needed to thresh out the absence of evidence against Mr. Muse for this advertising. There was no evidence. And this was raised by the commission, Civil Service Commission, but there's no record. I mean, the hearing.
Thank you.
Thank you.
Thank you. May it please the court, Hannah Sorokin for respondents. Your Honors, appellant here.
May I ask you, you're not pressing the untimeliness, are you?
We're not.
So that was the only ground that this was dismissed below, right?
It was also dismissed for failure to state a claim on the merits. So the court.
I'm sorry, I didn't hear what you said. Failure.
Failure to state a claim on the merits. That was the motion that was before.
They went, and even though he found it was not timely, he nonetheless went into some of the merits, didn't he, in the second page of his decision?
Correct. He addressed both. So apologies. The court addressed both. Found that the petition was untimely, which we're not pressing, and also addressed the merits and addressed the administrative decision. And here,
Doesn't the petition set forth, aren't there claims that the firing was arbitrary and capricious in this petition and in bad faith?
There are. That's correct. And the petition and the record, the vast majority of the administrative record is attached, is annexed to the petition. And it's clear from that, from looking at the petition and those records.
Is there anything in the petition, any fact in the petition, not legal conclusion, but fact, that you are disputing? Are you disputing that that the testimony was what it was? He said, I told them. Are you disputing that that's what he testified to?
Speaking to the co-instructor?
Yeah. I mean, is there any petition fact that you are disputing?
I mean, some of the framing, perhaps, but I think critically here, what the.
In terms, I'm trying to figure out, you didn't answer the petition, right? Which means that you are saying, as the facts as alleged, that is normally what it means, correct? Is that what you're arguing here? Even the facts as alleged in the petition don't state a claim. Here's the record. We agree that that's what this person testified to and that person testified to. With all that together, there's no claim.
That's correct, Your Honor. Apologies for misunderstanding. I think there were allegations in the petition that were conclusory, which we would not, but the fact allegations.
No, the conclusions of law, you're saying the allegation is it's arbitrary and capricious. Of course, that's what you're disputing. But I'm asking you, the factual allegations in the petition, are you disputing any of them?
At this stage, no, we're taking the allegations in the petition, except for ones that are contradicted by the record, which was submitted and annexed to the petition.
So weren't they contradicted by the record? And to the extent that the conclusions were that he owed a lot of money, and with the initial investigation by the Hostos individual was that, no, all of the money that was due to Hostos was provided, that they looked over the entire advertisement or whatever it was, and they approved it, the course description, and approved it. None of those things were all challenged at the end.
Well, the financial, that charge was withdrawn, and that's undisputed. The issue of payments being sent directly to appellant, that was relevant to the advertisements and his involvement, because the advertisements directed students and prospective students to send their registration and associated fees to appellant's home address. So
what caused the change from what the Hostos individual said, which was that they reviewed the ad, and the red light is on, I'll just be a moment, that they reviewed the ad and did everything, and yet at the end, he was found, and they had taken 2 charges out, and the issue was only that he was going to be demoted, and then there was a switch, and he was fired. What caused that change?
So he was initially at the step one, or when the charges were initially brought, his prior fairly recent promotion, he was reverted back
Right,
to his
and
prior position.
it was said that he would be demoted as a result of it.
That was pending the hearing, but at the
Exactly.
step one,
That's not what happened. Instead, he was fired.
well, ultimately, that was what the hearing was about, and the step one decision, at that stage, that officer, the hearing officer,
So they're saying that there was bad faith in that. Was that addressed below?
the court
bad
below
faith
found
issue.
no bad faith, that the decision was entirely rational, and it was based on, again, the pleadings here and the administrative record annexed, which showed that appellant here was highly involved with the course itself, with the advertisements. Appellant's focusing on who actually prepared the advertisement, but that wasn't what the administrative decision was based on. It was based on that he knew or should have known. Thank you.
Unless the court has further questions, I have nothing to add.
I beg your pardon? You
Unless
don't have
the
anything
court has
to add?
further questions, I have nothing to add. Thank
Okay.
you so much.
Thank you. ZDG LLC versus 310 Group.
Good afternoon, and may it please the court. Ira Schulman from Shepherd Mullen. The reason we're here, Your Honors, is because we believe the lower courts got it incorrect insofar as awarding the damages to ZDG following the inquest. I just have 3 points I want to make. Number one, there is no duplication between the breach of contract claims and the mechanics lien foreclosure claims, and that seems to be an issue.
So this was a termination of convenience, and it seemed, and you're asking for the termination of convenience and the mechanics lien. And the termination of convenience, it seems that the mechanics lien would have been double the amount that you got under the terms of convenience, which says you get a percentage of the amount.
The termination of convenience.
Just let me finish.
I'm sorry, I thought you were
The
done.
percentage of the amount was 55%, but you were looking and the 150, I think, for the termination of convenience. But you're looking as well for the mechanics lien, and I'm wondering how that is possible given 5.1.1 language that says, notwithstanding anything to the contrary, the construction phase fee shall not increase for any reason whatsoever.
Okay. I believe there's a conflation here between the general conditions and the 55%. Well, I need to explain this, if I may.
Okay.
55% was the amount of work completed that was approved by the owner. That's 55%. The general conditions that we seek as part of our damages under the breach of contract theory is different. The contract says the lump sum general conditions was $2.955 million, all right? They paid $1,157,000. We had another $460,000 in the mechanics lien. We're taking that out. So in our view, it should be $1,333,000. Why? Because general conditions is time related. When we had the general conditions, that was to be on the job for 26 months.
So you want to be paid for the entire time that the job should have taken, not the amount of time that you actually worked on it?
Of course, because they have admitted by reason of having their pleadings stricken that the project was delayed due to a failure to issue timely changes, issuing incomplete design drawings and specifications, failing to provide access agreements, and the like, which are all set forth in paragraph 25 of our complaint at record 28.
So by seeking 100% of this amount, aren't you seeking money for unearned work?
No. In fact, Your Honor, we were obligated to earn our 2.955 general conditions was to be on the job. We would finish the job in 26 months. We were on the job for 26 months. We couldn't finish the job in 26 months because of the delays and disruptions caused by the owner, which are deemed admitted because their pleading was struck. We're not saying, oh, pay us for stuff we didn't do. We did it. We were on the job for the full 26 months the contract, the project schedule called for. So we were there. If we would have been, it could have been many different scenarios, I suppose. But what happened here is that we were obligated to build this thing in 26 months, which we would have had not for the delays which were admitted by reason of the contract being struck. The 55% was just the amount the owner was willing to pay us. It would be, to me, not right if our damages were limited to that 55% for a defendant whose answer was struck, and that we should take that 55% as gospel.
No. But the fact of the matter is, it's a breach of contract action. No matter how you get there, you're only entitled to actual damages. That's it. That's all you get. So the fact, it doesn't matter how you get to that point. It just matters what you're entitled to. So it's
I can't argue with that.
You're not getting, so you're arguing I should get more damages because they're a bad guy. That's not how breach of contract actions happen.
I'm sorry, Your Honor, I didn't mean to interrupt you. What I'm arguing is that we should get what we're entitled to. And what we're entitled to is the full general conditions because we spent the full amount on the job that the contract called us to spend, the 26 months.
Even if all the work that was supposed to be done was not done?
That's not relevant when it comes to general conditions, Your Honor. General conditions, as I said...
But if your contract says that you are entitled to the fees that you earned, don't you have to do the work in order to earn it?
May I continue?
Please.
We earned that. We earned that by being on the job for the full contract amount.
Okay.
Aren't you asking for time that was 2 months beyond the estimated project duration?
We are, but for purposes of the
So that's not
argument,
actual cost then? So you're taking out...
I'm sorry, it was an average cost, and I'm just setting that aside for purposes of this argument. I may have one other minute, and then I'll step down.
You can do it on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Larry Hollander, Hollander Law Group. As a respondent also often does, I'll throw away my prepared text and jump in on the questioning. The 2 months period that Your Honor just highlighted is in fact a liability determination by the trial court that ZDG was in fact entitled to compensation for those 2 months beyond the 55% pursuant to 5.2.2. There was one little problem.
They gave an
with the
estimated
appellate.
amount, I thought.
They gave an estimate.
But he's saying he's putting that aside for now, so...
Well,
it
now
was
he is
because it
after
was
your
an
question.
estimated amount, it wasn't the actual.
Yeah, if he's dropping it, that's fine with me because they didn't carry their burden of proof, which is why the court said, and they got an adjournment to do it because the theory that an estimate of $1 a month for 9 months, as an example, is $9 means that your actual is $1 per month is blown away because it could be $3 a month for 3 months.
In any case, he's not arguing that right now because... So let's focus on...
This is very simple. The concept of the playing field here, that despite the striking of an answer, that the contractual provisions are enforceable, all 4 departments enforce that.
May I just ask, so for my clarification, you're saying that the council didn't put in the actual costs of that period that he is now seeking for general condition costs.
And that is
that's what the court found.
They did, very explicitly.
Right? Okay, that's all I want to make, right.
And they also found it based on credibility terms.
Right. So,
which is also very powerful because, as I'm sure I don't have to tell the court, to overcome a credibility determination takes quite an argument.
Right.
So the point was, this is really a pretty boring case. Answer stricken. Go to trial, get your chance. You proved 55% of what you did.
In your mind, is there any doubt that the mechanics lien was a double count?
Of course it is, because Learned Counsel only filed a lien for $193,000, even though they're $893. give or take a few shekels. Even though
A lot of shekels.
lira, euros, whatever. Even though they were seeking millions of dollars of damages, that's because they know that you cannot lien as an improvement to the real estate for extra contractual damages, consequential, attorney's fees. The court is well aware. So by their own admission, the amount they filed for the lien is exactly the amount of their contract damages. I hate to say no-brainer to an appellate division, but that logic is there. The lien law expressly states that a finding in an arbitration in a separate action as to the value of the improvement to real property establishes the amount of the lien. Breach of contract, lien.
And you're not disputing the termination fee. That was in the money, everybody agrees it was paid, you're not disputing that it wasn't.
We are not, but think for a second, Your Honor, the logic of appellant's
I'm
argument.
just trying to figure out, because appellant said I should have been awarded the termination fee, and I thought
Well, they got $150,000.
they got it, right? Yeah.
I have to stand by the contract.
Right,
I can't
right.
dance around
Okay.
those provisions. But here's the irony. On the one hand, they want the contractual damages under the termination for convenience, including the fee, and then they want millions of dollars more extra contractually in addition to that. So you can't have your cake and eat it too. I hate to be using these phrases in front of you, but again, this is a legally very simple case as far as recovering solely what you contracted for. I have nothing further if there's no questions.
Thank you.
Thank you, Your Honor. We obviously know each other.
Well, many years. Just 3 points, Your Honor, if I may. One, there's, in the overall picture, I guess it's not a lot, but there's $75,000 of remediation costs. We've proven nobody paid attention to it. We'd like the appellate division to give that to our client. It's $75,263. The evidence is in the record. There was no contrary testimony. I don't know why the courts didn't reach it, but we're entitled to it. Next, no one's looking to have cake or eat cake. What I'm looking for is to be treated in accordance with the contract. And the contract says in section 14.2.2, record 75, in the event of a termination for convenience pursuant to this section 14.2, construction manager shall be paid by developer all earned but unpaid portions of the construction phase and the general conditions lump sum up to the date of the termination for convenience. We earned that $2.9 million. We were on the job for the full 26 months. That's the deal we made. I don't know why they think it shouldn't apply. I don't know why the ZDG, which staffed the job, paid for the job, hired the consultants, whatever the
But
general...
again, on 14.2.2, that's regards actual costs. Aren't you estimating costs for that?
No. It's a lump sum general conditions. The contract does not itemize it. The contract says you will be paid a lump sum general conditions of $2,955,000. That was negotiated by the parties at the time the contract was executed. So I don't have to prove...
And you're getting the 55% of that.
I don't want the 55% of that.
I got that impression.
I want the amount that we earn by being on the job for the full contract provision. Lastly, Your Honor, I believe the arguments that were raised by my learned counsel are fully addressed in my reply brief to which I refer to you. Thank you very much.
Thank you both.
Thank you.
People versus Tara McDonald. Maybe.
Good afternoon, Your Honors. My name is Tomoe Murakami-se, and I represent Appellant Tara McDonald. The single most important aspect of this case is that there was an explicit finding by the court below that Ms. McDonald did not commit a sexual crime, in this case or ever. That
Well,
her
aren't
last-
we-
Can I? Can I just jump to a question? It seems that I mean, we know that, but it seems that the facts of this particular case are very, very similar to the case that was before the Court of Appeals, or at least one of the three cases that were before the Court of Appeals in People versus Knox. And how do we get around that?
So, Your Honor, the key difference is the explicit finding that we have here, that she is not a sex offender, never has been, never will.
So those were the facts in Knox.
There was
and
no
doesn't
explicit finding, and I think that, I'm sorry to interrupt.
So let me just finish my question.
Yes.
So in Knox, it's not a person who was in any way a sexual offender. And even more so, doesn't the case, the recent case in Brown, the Court of Appeals case, doesn't that sort of seal the fate of this defendant, where the court talks about it embraces, and of course in Brown we're talking about someone who went into a home not at all in any way to kidnap a child, but to rob the home of a relative. Anyway, and the child was there. But doesn't the Court of Appeals embrace the Knox theory when it says that the Knox defendant totally distinguishes it and says the Knox defendant was homeless and suffered from substance abuse and extensive psychiatric issues? Taking the child was her objective, and if Knox had been successful in her attempt to kidnap and remove the child from the safety of the everyday surroundings, the child indeed could have been left vulnerable to sexual abuse or exploitation. Aren't those the very facts of this particular defendant, that she was taking the child out of the carriage because she thought the child would suffocate, or she wanted to protect the child? Same thing in the Knox case and the Brown case. It sort of reaffirms Knox in its explanation of the passage I just read.
I don't think so, Your Honor. And the theory, first of all, the prosecution position below was quite clear. They said Knox is a bright line rule. It applies. They didn't argue any of this. Even though Ms. McDonald would never become a sex offender herself, she might, someone who kidnaps might isolate the child, and then someone else who might sexually abuse the child might come along. None of this attenuated, restrained argument was argued below. Their position below was bright line rule.
Can I interrupt you for a moment and just ask you, I want to make sure, the legislature has decided that kidnapping without the sexual component of the child is part of the SORA rubric, correct? There's no, I mean, there's statute. The legislature has said this is one of the crimes for which you have to have a SORA hearing, correct?
Yes, but that's separate and apart
So,
from the...
okay, so the only way to get around what the legislature has said, because that's what the people of the state of New York have decided, we'd have to find the statute unconstitutional, correct?
Not the statute, as applied.
As applied, we'd have to find it as applied unconstitutional.
Yes.
And so then the question is, hasn't Knox and Brown said it is? It is in this circumstance constitutional. How can we go against Knox and Brown?
Your Honor, I think the respondent's position really ignores the holding of Brown. The Knox rational basis holding rested on the statistical relationship between kidnaps and sex offenses, as well as this administrative burden of having to separate out non-sex offenses, non-sexually motivated kidnappings. And Brown said, and they say this quite repeatedly, where there is an explicit finding that the crime was not sexual, this rational basis thing that Knox talks about does not exist, and that, quote, it is precisely because there is a factual finding of defendant's lack of risk that defendant's as-applied challenge must succeed. That's on page 291. They say it again, where SORA court expressly finds that there was no sexual conduct or motive and no risk of future sexual offense. Application of the SORA label cannot be
Let me ask you,
justified.
did Justice Troutman and did the two concurring judges join in that part of the decision?
Everything I'm reading is
So
from
then
the majority.
what do you think, why didn't the court overrule Knox?
Because in that case, well, clearly some of the judges wanted to, but I think that
wanted to, but five said no. Knox is still good law. The case
because I don't think it needed to go that far in that case. But I think the court doesn't need to go that far here either. I think this is very much a Brown, Diaz type of analysis.
Can you tell us again what Ms. McDonald is no longer, if she is a registered sex offender, what she would be barred from participating in, like certain places that she couldn't live, et cetera? She is someone who needs support. Could you tell us specifically what the impact for her is by being a registered sex offender?
Yes, Your Honor. So, as we argue below, this is a 66-year-old, smart, tiny wisp of a woman who, whose strawberry blonde hair is now completely gray. She's she's been out since 2018. She has not reoffended. I think the people's only concern below was that she's going to do this non-sexual offense again. She has not done that. And even without the benefit of a placement like the Bridge, which is where she was quite literally the poster child for someone, proof that someone with a severe mental illness can succeed. She was going to college, she had a job. Even without that benefit of a wraparound, she has still not offended, she has not been arrested, no police contact whatsoever. And I think that speaks volumes about the kind of person she is, and how old she is getting, and how frail she is. I see my time is up. I'll save the rest for rebuttal. Thank you.
Good afternoon, and may it please the court. Matthew Colangelo for the people. This case is entirely resolved by both Brown and Knox. On the facts of this case, there really is no meaningful distinction from the case of Judy Knox, who approached a girl in a Manhattan park, an 8-year-old girl, took her by the arm, tried to take her out of the park, and was interrupted before she was able to do so. The Court of Appeals held in Knox that requiring the defendant in that case to register as a sex offender did not violate substantive due process, notwithstanding that there was no sexual motive. And the court in Brown just 2 years ago affirmed that decision.
So we know what, I think you could hear from the questions we asked that we're fully aware of Knox and Brown. Your office prosecuted this case in this way, and we now hear that we have a defendant who has not violated anything since 2018. I don't think there's any question that anybody thought that she was intent on doing any, committing any sexual acts, or that she falls under the usual definition for a SORA defendant. So what happens now when we have another case on this calendar that you may not be here for, maybe it wasn't argued, where the person was a level 2 and they were a serious sexual offender? This woman is a level 3. The kind of restrictions for a level 3 sexual offender are extremely severe. What do we do about this particular individual?
Well, Your Honor, a few responses. First, the court designated Ms. McDonald the lowest level sex offender, and in response to a question,
I think they reduced it to a level.
Correct. They reduced it to the lowest level, and I noticed that
You're not challenging that, right? You're
no,
not
correct. Not challenging that at all. Not challenging that at all. And I would point out that in the appellant's reply brief, she notes, this is at, I believe, page 10, footnote 11, but she notes at the end of her brief that notwithstanding what was described in the opening brief as the barriers imposed by housing providers and social service agencies as a result of her SORA registration, she notes that she has not reoffended since being released from custody in 2018. So, Your Honor, I think that suggests that the barriers are not so restrictive as to impede her recovery. And what's more, I think they point out the importance of the importance of having a registration requirement in this case. The defendant went several years without reoffending after earlier convictions for attempted kidnapping, and then relapsed, had a recurrence of her mental illness, and the pattern of attempted kidnappings recurred. So there's nothing to say that that can't happen again, and shouldn't daycare providers, shouldn't nursery schools be able to determine, if she applies for a job, that she has a mental illness that impels her to try to steal babies and take them away from their caregivers or parents. And so the risk that the Knox court identified and that Brown affirmed is the risk not that she would commit a sexual crime, but that she was taking a baby away from safe surroundings and exposing that vulnerable baby to the risk of future sexual harm.
What about counsel's
understood.
argument and what is held in Brown that they made a distinction with Knox, that if the SORA court found explicitly that there was no sexual conduct or motive for future sexual offense, the application of a sex offender label cannot be justified? And
So-
that's from Brown.
That is from Brown, but the quote that counsel gave was incomplete. The rest of the sentence is, application of the sex offender label cannot be justified on the ground that a defendant may pose a risk of future sexual misconduct. That people are not saying that Ms. McDonald poses a risk of future sexual misconduct herself. There is no evidence that she will commit a sex crime, but there is evidence that by taking her away from safe surroundings and by taking babies away from safe surroundings, that she's exposing infants to sex crimes by others, which is exactly what Knox said.
And in
legislature
Brown,
could be
the
concerned
child was not the target. Here, as in Knox, the child was the target of the crime, right?
Exactly, Your Honor. It's a critical distinction. The Court of Appeals said it was the most
There's no
important.
doubt here, the child is the target of the crime, not just incidentally in a house where a crime takes place.
Exactly.
I think that's where I started with the
Thank you, Your Honor.
distinction.
If there's no further questions, the people believe the judgment below should be affirmed.
So that was the target, non-target, that was definitely not the most significant part of Brown. Brown's holding, which respondent keeps ignoring, is very clear, where there is an explicit finding by the court below, our administrative burdens, all those concerns are gone. Let's see, there have so many quotes to choose from. Page 287, first and most significantly, the SORA court here expressly found that defendant is not a sex offender. No such finding was made with respect to any of the defendants in the Knox appeals. That's People versus Brown.
But then there were the other facts in Brown that are the ones that are significant, because what you just said is true for the Knox individual, it's true for this individual, but then the added information was the circumstances of Brown that really distinguished it.
I think Brown, Judge Rivera in Brown, in the majority opinion, explicitly says what differentiates this case is that there was no explicit finding by the court below. That was, to her, the overriding.
I think what,
It didn't sound like that, sorry. It didn't sound like that was the overriding explanation in the decision written by the chief judge, which was that this was different because there was in no way was this child the subject. It was the robbery of his aunt's house, and his cousin, who was a child under 17, happened to be in the space. He was there for money, not for a child, and that, in addition to the fact that the child was not, that was the thing that made the difference, not just the fact that this was not someone who was a SORA, the typical SORA individual.
I think 1, 2, 3, 4, 5, 7 times in Brown, in the main part, it talks about the express finding and how that is the difference.
And that is an express finding here. You're right.
There is an express finding. There was not.
That she is in no way a typical SORA individual. But the other factual aspect is that her main goal was to take this child and to remove the child away from where the child was in order to protect the child, because she thought the child was suffocating. And that's what her criminal history shows for 2 or 3 times prior to this time.
So she has never removed the child from.
She never was successful.
Exactly, precisely. I think respondent goes too far in trying to analogize to Knox. Here in Knox, there was a specific finding that she was trying, that Ms. Knox was had lost a child and trying to make the child her own. Here, the finding is, let's see, that we had an expert who looked at decades of her records. Who
But the
interviewed her at
facts
the time
here
of
are
the crime.
that she's trying to
Yes.
wrestle the child from the person who has the child in the carriage, and she was unable to do it.
This is what the expert said, testified. The expert said, she needs to protect, and she intervenes. That gets her arrested. And then the court went on to say, having heard witnesses who testified as to what precipitated these actions, the delusions and the desire to protect the baby. Quote, there is no doubt that there is nothing about these particular crimes that have any sort of sexual element to them. None of the crimes that Ms. McDonald has committed. SORA is for people who commit crimes other than sexual in nature against children. And then the court encouraged Ms. McDonald to appeal this case all the way because, quote, ultimately,
And perhaps
I do have
that
to
you'll
follow
do
the law.
that. Thank you.
Okay.
Thank you both.
Thank you.
Board of Managers versus Park Associates.
Good afternoon, Your Honors, and may it please the Court. I'm Josh Herman. I represent appellant plaintiff in this matter. So before looking at the language of the declaration and bylaws, I'd like to start by considering the absurdity of respondents' interpretation of these provisions, which is that the bylaws provide that they can operate a commercial parking garage servicing members of the public, and that the costs of maintaining the surface on which the cars drive on and any costs associated with repairing degradation of that surface should be borne by the residents of the building who may not ever set foot in that.
Well, isn't there an issue right now about who is responsible for the water infiltration that has occurred over all of these years? I think each of you has an expert, and perhaps this case is best decided by a jury trial where experts have the opportunity to go forward. But at this point, one of the experts hasn't even had an opportunity to have access to the building or the garage.
Respectfully, the issue of who has caused water infiltration or which party caused water to come in, that's an issue that only needs to be addressed if you first found that the waterproof membrane that's supposed to prevent any moisture or water from coming into the concrete was the responsibility of a party other than the garage owner.
But it's not just about I understand that's the position that you take about the waterproof membrane, but your opposing counsel, I'm sure, is going to argue that it's more than just the water that fell on the waterproof membrane and whether that had been replaced or taken care of. It's that there is a larger issue with regard to water infiltration, and it's not clear whether it's the larger issue or just the lack of repair to this topper.
Right, well, yes, there is a dispute. If it does come to it, there would be a dispute as to whether or not the cause of the water came from water dripping off the tires of cars or whether the water came from other damage in the building. That, I admit, is a disputed fact. But, Your Honor, in order to reach that fact, both parties concede that it's water causing the damage. We think that it's salty water coming off of tires, and that the salt is.
I mean, but you're asking for summary judgment. I'm finding it difficult how you are entitled to summary judgment where you have two experts, and it seems to be they're saying opposing things, and one of them doesn't appear to have had access yet to be able to complete any sort of examination or anything he would have done. You're asking for summary judgment here, is saying there's no issue of fact.
Well, one issue on which I don't think there is any dispute of fact is that if there had been a waterproof membrane in place that was well maintained and functioning, then water would not have gotten into the concrete.
We don't know that. Based on the experts, that's not clear.
Well, we did introduce evidence from our expert,
One
John
expert.
Grundy. Yes.
There are two.
Well, in summary judgment, the expert would be required to introduce some evidence that the waterproof topper would not have been effective, that it would not have resulted, that it would not have been able to prevent the damage. And that expert, I think his name was Stasio.
But wasn't there also evidence that, I mean, in addition to what you're saying about the waterproofing membrane, that there was also water infiltration in the building and the garage for many years that one went unaddressed or not remediated by the plaintiff, and that would have to be determined first? I mean, it seems that the experts and the evidence have presented issues of fact that preclude us from finding for you on summary judgment at this point.
Well, I think the first point I want to make is that if this court were to find that there are these other facts as to what was the cause of the water and what caused the water to come in, how long it had been there, it would still nonetheless be, as a practical matter, helpful to the parties in framing the issues for trial to determine on summary judgment the declaratory judgment aspect of our motion that was requesting clarification on who was responsible for maintaining the waterproof topper, because that issue does not need any external evidence. It doesn't require testimony of parties. It's simply a matter of what does the declaration and bylaws say. And if we know who's responsible for that waterproof topper, then this case is solely a matter of whether or not it was maintained, whether it would have prevented the damage. Yeah.
Afternoon, Your Honors. Jeffrey Metz for the respondent. Your Honors are absolutely correct. Summary judgment is inappropriate at this stage.
What about the comment, so I don't forget, that he just made now about the declaratory judgment about who's responsible for this membrane? I mean, is that something that we can determine at this point?
Well, if you look at the order of Justice Saunders, she ran through this analysis of 5 and 6 to find that there was a dispute as to what "from" means. And as a result, she found
how to measure it. Right.
She found that the documents were ambiguous, and this court has found when documents are ambiguous, it's inappropriate to grant summary judgment.
What if there's no question with regard to the topper, the top of it, the vertical, line of this from the top to the bottom surface?
Sure.
What if that? Then what about the question that Judge Kapnick has asked about who's responsible for the topper?
So you have to
about not who's responsible, but whether or not there could be declaratory.
You have to understand, when they brought the complaint, if you look at the complaint, there's no mention of any waterproof topper or membrane or anything there. It's absolutely not in the complaint. First thing that they argued was that us as unit owners were responsible for the repair because allegedly we were negligent. Then, when they got in front of the court, they said the main issue to decide is whether the garage unit itself was a common area.
You know, what I thought you were going to say was that the erosion that you argue, that there's a water erosion from the building, has led to the advance of the topper, and therefore replacing the topper is only going to lead to more deterioration of the topper. But you've said something else.
That's where I was going with this. If you want to even take a look at this membrane issue, which I think is a red herring, Judge, back in 2015, Grande, who put in an affidavit, an expert affidavit, prior to litigation, 7 years prior to litigation, he said, and it's on page 218 of the record, said well in advance, he said, source of water infiltration into the cellar level is attributable to, it was a defective membrane on the planter, there was a defective membrane on the drainage, improper drainage, found that there was defective membrane on the membrane that was the ceiling before we even got to our garage. And he gave suggestions to cure that, ignored. When we wrote to them, after nothing had been done, we gave suggestions to cure, ignored. So what you have here is 17 years. I mean, this is pretty amazing when you think about it. Even they said that these infiltrations started in the year 2000. They did not get around to even dealing with this to 2017. So if you want to say that salt is responsible for the degradation of the membrane, well, you can say that. I mean, we will defend that at trial every day, because you'd have to be like in Alaska or something like that, where you would have cars constantly coming in with salt, and they would winter all year round. But here, it is very clear that this is a low transient garage, basically for the people in the building. It's not open to the general public. So you want to believe that, you can. Me personally, I think it's absolutely incredible what his expert said, but I will concede, I will concede that there is a dispute.
Let's focus on
amongst
what the expert
experts.
said or on some other.
Yeah, I mean, sure. I mean,
legal point.
Look, summary judgment has to be denied because there's a question of whether it's a common element, although concrete floors and ceilings, and this is a concrete slab that's between a floor and a ceiling. How there's any issue about that, I don't understand.
Thank you.
Okay, thank you, Judge.
I'd like to,
So I just want to make sure, your argument is that the topper, I mean, the document says the slab to the slab. So the topper is on top of the slab, so it's the garages.
yes, Your Honor, that's right.
Right. So you're saying that that's clear from the documents.
Yes, Your Honor.
All right.
Just as if epoxy flooring had been poured on a residential unit.
And the documents are clear. It's slab to slab, and anything that goes over the slab that's in the air is the garage's the commercial unit's responsibility, right?
Correct, Your Honor. And in
Your argument is it's the degradation of that topper that caused the damage, and it's the garage's argument that it's your 17 years of not repairing all the other stuff that actually caused it, right?
correct, that's a separate factual issue.
So I'm just trying to figure out, do you believe that the condo doc or the condominium documents are also ambiguous?
Your Honor,
That issue, who has responsibility for the topper?
I do not believe that the documents are ambiguous, but I will point out that in the Pearlbinder case, which was
Right,
affirmed by this court.
exactly.
Yes, it found an ambiguity, but nonetheless resolved it in the way that I've been suggesting it do here.
Okay.
What do you think of counsel's argument that without knowing the cause of the damage, you can have summary judgment?
Well, I think that it fails to address the fact that whether it was caused by water, another question is, was it prevented? Could it have been prevented by the waterproof membrane? Because that is why it was there. That it was intended to do was to enable a garage to be operated on top of the floor without causing damage from water or snow coming off of tires.
But isn't that issues of fact, as you say that they could have done something to prevent it?
Well, at this stage, I don't think there is an issue of fact that's been presented by respondents' papers. There hasn't been any evidence introduced to show that the waterproof membrane would not have made a difference. There's a one-sentence statement in his expert's report that says conclusorily that the waterproof membrane would not have made a difference, but there's no actual analysis of that issue.
Thank you. Thank you both. De Jesus Jimenez versus Rodriguez.
Good afternoon, may it please the court. My name is Tom Keene. I represent the appellants, Mr. Rodriguez and MJJ Services. I'd like to talk to you about a case that was argued before Judge Renwick, Judge Mendez, and Judge O'Neill at the beginning of this month and was decided last week. It's called Martinez versus Martinez. And I mean, these are simple cases. The brief is small, the record is small. You decided that summary judgment was improperly granted because there's a question for a jury to figure out whether the SUV made a bat U-turn on 14th Street or the moped went zipping through the other lane. That was a pure question of fact. The question of fact here is, we say the plaintiff went around a stopped van with no headlights at high speed and hits us while we've already almost completed the left turn, and plaintiff says, defendant hit me while making a left turn. That's all plaintiff says. I think you've seen in my argument that how scant the record was on that. And the only other thing I want to say.
And the police accident report shows a head-on collision.
You're right, Judge.
Which is very different than the case that you give to us, Martinez versus Martinez, where the police accident report was after the fact and showed something very, very different.
Right, but this wasn't a head-on collision, was it?
No, Judge Reinhardt.
No, I'm saying that didn't you provide us with the case of Martinez versus Martinez?
I did.
You did. And that is the case that was not a head-on collision that I was on.
This case is also not a head-on collision.
But it's an intersection
It is an
collision. And I'm saying that the case you provided us is not an intersection collision. It is very different.
What's the same about Martinez and this case is that there are two different sides telling two different stories, and a jury has to figure out.
There were other reasons in Martinez that are not here in this case. The case is very different, is what I'm trying to impart to you.
All right. Again, though, under a plaintiff did not make out a prima facie case, and in fact, the judge said, you didn't ask me for a time to reply. I'm going to give you time to reply, and when you have time to reply, you need to tell me about the lighting conditions and the points of impact. And plaintiff.
And that did not, right? The responsive papers did not deal with those issues,
That is
did they?
correct. They were presented a golden opportunity and didn't do it. And Judge, I'm sorry, if you thought I tried to mislead you about the facts.
No, I was just clarifying that I don't find it persuasive.
So in this case, you're saying there are issues of fact that need to go to a jury?
Absolutely. That's it. Thank you all.
Thank you. $538 Morgan Realty versus Law Office of Aong Yu. You may begin.
Good afternoon, Your Honor. My name is Jeremy Deutsch. May it please the court, I'm here to represent the appellant plaintiffs in this action. The court below dismissed appellant's complaint, which alleged one count of legal malpractice on the grounds of causation and on the grounds of damages. The court, we believe, applied the wrong legal standard and failed to give the plaintiffs the benefit of the inference with respect to either of those things. There are two acts that were complained of. One is the failure to make a motion to strike the liquidated damages provision from the contract. The court below erred when it considered and analyzed that provision of the contract. The court held us to a standard that we were required to prove that the contract would have been unconscionable or voidable at that time, and that's the wrong legal standard. We were required merely to plead an inference that we would have that result. If you establish or if you accept the trial court's view of what is required in these circumstances, legal malpractice is essentially read out of the books in New York. The reason being that you can't plead a counterfactual, which you're required to plead when you're pleading a negligence claim, if you don't accept the fact that you're pleading uncertain future events, which is what the court said that were inherently speculative below. The inherent speculation in
So, counsel, may I ask you, okay, the second law firm, though, you've sued for failure to move to find the liquidated damages clause unenforceable. That second law firm didn't come in until after that motion was decided, after the note of issue was filed, after the time for summary judgment. So how could that law firm, the second law firm, be responsible. And in fact, did ask at the end of the trial to get rid of the liquidated damages clause. What did that second law firm do?
So, Your Honor, that second law firm, which served as co-counsel to the office of Ms. Yu, if you look at paragraph 32 of the complaint, we plead that they specifically said that in an email.
But it doesn't matter what they said. It's a matter of what could they have done.
I see.
So I'm saying they didn't come in. They couldn't have said anything to the court until after that issue had been decided, and at the time that they went in for trial. And they did actually do what you asked at the end of the trial, and I think the trial judge said too late. But they didn't have the opportunity that the first law firm did. So again, I'm trying to figure out why you think that claim is good as against that law firm.
Sure, I didn't understand your question. I apologize. The claim is good against that second law firm because discovery was still ongoing even after the note of issue had been filed in that case. The Gonzalez case from the Court of Appeals makes clear that good cause will be shown if discovery relevant to the facts is still going on to a motion for summary judgment. That motion was never.
So now you're saying that that law firm should have made a motion and that would have been granted for late motion for summary judgment, and that late motion for summary judgment, not only the motion to have it would have been granted, but the motion to strike, which the court had already denied, would have turned around and said, no, I'm going to change my mind?
So several responses are required to your question because it's multi-part. First,
you're correct. I'm sorry, I tried to make it easier, but it does seem like it's a response to your response.
I appreciate that, Your Honor. First, there was no motion to strike the liquidated damages provision at any point.
Wasn't there right before trial?
The motion that you're referring to.
That was the motion in limine?
The motion, I was just going to say, the motion you're referring to is the motion in limine. I think that the notice of motion appears and the motion itself appears at 11:15.
So counsel did make that motion.
No, Your Honor. They made a motion to exclude oral or parole evidence with respect to the cash that had been received by my clients in connection with the contract. That is a relevant point, and that goes to the conversion claim. It doesn't go to the liquidated damages claim. It doesn't go to it in any way. It doesn't even really go to the conversion claim because it doesn't attempt to deal with the piercing of the corporate veil issues or the personal liability issues. It goes to an evidence issue. That motion was not granted. So the motion that was made was neither a motion for summary judgment, nor was it a motion addressed to the issues that we have complained of. And again, if you refer to paragraph 32 of the complaint, you'll see that it is specifically alleged that that second law firm spoke to or emailed with my clients and said, Ms. Yu is planning to make a motion for summary judgment. We would like to join and work on that motion with her. That motion was never made.
Hadn't the Yu defendants made a motion to strike the note of issue and file a late summary judgment motion?
They did.
They did. So that motion was made. You're saying that this law firm should have made it. The motion was made and denied. So how can you say that it's malpractice not to make that motion when?
For two reasons. And I recognize my time is up, but for two reasons. One, the motion that was made without reference to good cause, and it was made without reference to what the court Ms. Yu was asking the court to grant her permission to do. More importantly, that motion was actually unopposed, but it lacked so much in the way of merit that it was denied. But we don't know what she was going to ask the court for permission to do, but she didn't say it and she didn't get it, and the court and the other law firm was engaged with her to do it.
Thank you. You'll have rebuttal.
Thank you so much.
Good afternoon, Your Honors. Brennan Breland, Kaufman, Borgeson, Ryan for the Yu defendants. Might it please the court. This matter involves a group of property owners who were sued after breaching a contract to sell their property. They were displeased with the outcome of the lawsuit. They ultimately settled the lawsuit after an adverse verdict was reached. The result of the settlement was that they made an additional nearly $600,000 on the real estate transaction. It's a good thing the deal fell through, or they wouldn't have anybody to sue to try to make up their loss for failing to foresee the dramatic property value growth over time. Although I will generally rest on the briefing, there are a couple of points I'd like to address. First, legal conclusions masquerading as factual allegations are not entitled to any deference. I would submit that an allegation in a complaint that had a motion been made, it would have been granted. Specifically, had a motion to invalidate the liquidated damages clause been made, the court would have found it unenforceable, is not in any logically coherent sense any different from the threadbare legal assertion that the liquidated damages clause was
Except
unenforceable.
here, your law firm told the plaintiff, the allegation is, and we don't know, this is a pre-answer motion to dismiss, that it was unenforceable. It's not right?
Sure.
So it's not, so you thought that that motion would have been granted, or at least that's the allegation.
Perhaps.
So it's not really a conclusory when the law firm is giving the client the advice that it is unenforceable, and then the court enforces it because you haven't moved to strike it.
I understand your position. I would also submit that the fact that the defendant sought to enforce the liquidated damages clause as part of the counterclaims against the buyers is a reasonable litigation strategy that cannot form the basis of a legal malpractice action, as was determined in the RTW retail wins case that you were on, and you were also on, Justice Renwick, Renwick, sorry, I got my panels mixed up, and citing the Wagner-Davis case that Justice Katnick was on.
What about the failure to take measures to protect the individual plaintiffs from liability?
Yes. So with regard to the allegation that it was legal malpractice not to move to dismiss that claim or to move for summary judgment on that basis, first of all, there was evidence at trial adduced that was sufficient for a jury to find as a matter of a factual finding that the conversion claim was not only legally sufficient, but factually supported by a preponderance of the evidence, suggesting the weakness of this allegation. Nevertheless, it also represents a reasonable litigation strategy, which under the prevailing case law cannot form the basis of an action for legal malpractice. The final matter I'd like to address is all of this is designed to distract this court from the notion that the entire theory of damages is following appellant's breach of the property contract, the defendants should have moved to invalidate the liquidated damages clause or otherwise move to protect the individual appellants, so they would not have been forced to make an additional $580,000 over the value of the contract that they signed. In other words, absent this alleged malpractice, the appellant should have been permitted to extract further additional windfall from their wrongful breach of a property contract. None of these things that we're talking about, the alleged malpractice, the failure to move to invalidate the liquidated damages clause, none of these things obviate the ultimate flaw in this case, which is there is no coherent theory of damages. As a result, this court should affirm the decision in order below, dismissing the claims against the defendants without limitation or modification. Subject to any of your questions, I'll rest on my briefing.
Thank you.
Thank you.
Good afternoon, Jamie Wasman for the co-defendants, the Smargazi defendants. This was a very simplistic pre-answer motion to dismiss, and the trial court got it right 100%. In order to plead legal malpractice, the plaintiff had an obligation to set forth facts tending to show that had a motion to renew the motion to dismiss conversion claim been filed, it would have been meritorious. They had to allege what new facts would have been offered in support of that application. They have to state what arguments would have been advanced, why it would have been meritorious. The complaint fails to do that. Likewise, the plaintiffs would have to set forth facts within the complaint that, if proven true, would show that they would have prevailed on a motion for summary judgment and with respect to the liquidation damages claim. They don't do that. They don't indicate what arguments would have been able to been raised.
But okay, but this is a pre-answer motion to
Yes,
dismiss.
but all they do, respectfully, is simply say, had the motion been filed, they would have been granted. That's
Well, okay, so, but, all right, 1, 2, 3 things. 1, everybody testified that it was a penalty. I mean, it's not just, I think what you're saying is really not quite right. Their lawyers are telling them it's unenforceable, it's a penalty. 2, both sides testify at trial, it's a penalty. So clearly, it's a little bit more than, had I filed that motion, it would have won. Everyone would have put in affidavits, presumably, consistent with their trial testimony, and the court may very well have granted that motion. The question for you is whether you should be held liable for that, because where you are.
100% no. As Your Honor clearly saw, and I am thankful that my brief articulated this, the complaint was filed in June of 2015. They retained the co-defendants to represent them, they being the plaintiffs. The co-defendants made a 3211A motion. My clients were not counsel at that time. That motion was denied mostly. I think one cause of action was dismissed. The time to appeal that expired. The time to move to re-argue expired. No motion was made, no notice of appeal was filed. My clients were not their counsel at the time. The note of issues filed in February 2019. My clients are not the plaintiff's counsel at the time. The time to file the motion for summary judgment comes in June of 2019. My clients had yet to be retained. The plaintiffs didn't file a motion for summary judgment, but my clients were not their counsel. My clients were not retained until September 2019. There's no allegations, and this is one thing that really threw me with the reply brief that was submitted by the plaintiffs and before your court. Good cause is not mentioned in the pleading. Good cause is not mentioned in the opposition to my pre-answer motion to dismiss. Good cause was referenced within the trial court's decision, and so the plaintiffs jumped on it and refer to it in their reply brief, but their complaint, and again, this is a 3211 motion, their complaint does not allege that there was any good cause that could have been raised in support of an application to file a late summary judgment motion. So all of his references to good cause should not be entertained by the court. Unless the court has any additional questions for me, I will rest on my brief and respectfully submit that the decision should be affirmed.
Thank you. Counsel, could I ask you a question?
Of course you can.
The first defendant that argued indicated that there wasn't too much of a claim for damages. I thought that you had alleged in your complaint a much more significant amount of damages and differential in property, in the amount of the property when it was actually sold than he was seeming to allude to.
That's correct, Your Honor, we did. We alleged that, but for the malpractice that took place here, we were forced into a settlement to sell the property for essentially what turned out to be half the value of the property.
At the time you sold it, it was around $9 million, is that right?
Correct.
So I don't know where he got 600,000 from, but I didn't think that's what your complaint said.
That's not what we said. That's correct. They also said that we pleaded solely legal conclusions. That's not correct. This is a negligence claim in the context of a legal malpractice claim. It's going to sound like a legal conclusion. You have to use legal words to describe legal wrongs. That doesn't make it a legal conclusion. We alleged facts, and the facts are apparent in the record that shows that there was a significant disparity in the contract price and the value of the property. We said that this was essentially a $5 million penalty on its face. We said and it's apparent in the record that, and Justice Garpula referenced the testimony at trial was that it was a punishment, it was a fine, it was a penalty. This is not conclusory allegations. These are facts that were rooted in what took place in the court below, in the underlying action. Moreover, they reference the fact that the conversion claim, that they say that we improperly pled that. They told us they were going to move on the conversion claim. That's what they told my clients. They didn't make that motion. They were supposed to make that motion. I see my light is up, so unless the court has any further questions for me, I thank the court for its courtesy today.
Thank you. Thank you. Thank you all. Health East Ambulatory versus Countrywide Insurance.
May it please the court, Karen Newworth for Health East. The appellant met its burden of proof of timely mailing of the invoice. It did. And how did it do it? It did it by offering the admissions against interest of respondent that were contained in motion papers. The lower court found this, and the appellate term agreed. So that's, I think, done. Now, what the appellate term held is that although appellant met its burden of proving timely mailing of the invoice, the respondent's motion papers, quote, also established that defendant timely sought verification, which was not provided. As a result, plaintiff failed to establish prima facie that the claim was overdue.
And your position is they did not do that.
Correct. That was the next point I was going to make. They did not. You know, as a threshold matter, respondent never even offered those self-serving statements into evidence at all. And as this court has held in the case of Nasser, which was in my brief, if some statements are offered in a complete list of statements, and then the party who made the statements doesn't offer the other statements,
This was an evidentiary issue, and this was an evidentiary issue. And
Correct.
there was an admission against interest, and that's why that was allowed. And the other one was a self-serving interest that wasn't corroborated, or no witness appeared to be crossed on it so that it could be challenged.
That's correct. I mean, I could almost stop talking because you've
Okay.
articulated
And
so.
if you want to, that's okay too.
I'll say a little bit more, but not much, because I think that's the crux of it. You know, I mean, if the appellant had offered these self-serving statements, which have no credibility, respondent had offered them, the appellant would have objected, and the lower court would not have received them, and it would have been appropriate not to. If instead the respondent had offered a witness at trial to the verification request, the appellant could have cross-examined, and who knows what the finding would have been. But we never got there because that never happened.
Nothing much happened. I mean, it was a very short trial.
It was very short. It was just
a few
admissions.
pages of
It was a
testimony.
conversation.
Of discussion back and forth, and that's kind of was missing a little bit there to get the documents into evidence.
Well, I think what the appellate term might have been, and I'm speculating here, but might have been reacting to was the fact that it was so short, and the appellate term thought, you didn't do enough. But in fact, it was enough, and that's what the no-fault law says. You know, that's all they needed to do. Take these admissions against interest that said, yes, indeed, we timely received your invoice and we didn't pay it, and that's it. And then it was their burden, which they did not meet, to then say, oh, but we mailed timely verification requests and you didn't fully respond to them. They never met that burden, and therefore the appellate term was wrong to say that they did.
Thank you.
Good afternoon, Your Honors. Jason Levine for the defendant respondent. We submit that the appellate term was correct, actually, in dismissing this case because, as the court pointed out, this was a little bit of an unusual situation here. I use the term trial in quotes because there really was no trial. This case was marked final for trial.
It doesn't matter what it was marked. It only matters what came into evidence and whether or not it was appropriate or what. So what challenge do you have for the fact that Why do you think what the appellate term did with regard to the evidence was accurate?
Right, well, the plaintiff, as part of their prima facie case, in order to establish that, had to show two things under the Court of Appeals case in Etienne against Countrywide: proof of claim and that the claim was overdue. Normally, that would take place at a trial through a live witness from the plaintiff who would testify that, okay, here's the bill. This is a business record generated in the ordinary course. It was mailed on such and such date in accordance with our office's business practice.
Okay, but they had filed their notice of claim. I mean, I think that they had that, and
I'm sorry, Your Honor. I submit that, yes, the first part of that in terms of the proof of claim, again, they decided not to bring in a witness. Instead, they decided to rely on Countrywide's prior motion for summary judgment. Okay, and I'll acknowledge, look, that motion
an
establishes...
admission against interest can establish a point, which is what they did.
With respect to the bill being received. However, the balance of the information in that motion did not establish that the claim was overdue, as the appellate term.
You're talking about the language in there that was, I'm sorry.
The request for verification?
That was exactly the request for verification, but the request for verification was from the defendant.
Everything was from the defendant in that
Exactly,
motion.
it was from the defendant, but it was consistent. It was not inconsistent with the defendant. In other words, the plaintiff, that document came from the defendant. It was an admission against interest that the plaintiff was putting in. Now, the defendant wanted to use it in their favor, but it was their document. So they cannot use it in that way. They had to have a witness. There's no ability to cross-examine. So they had to put in a witness with that.
I would disagree with that, Your Honor, because the defendant was not using it. The plaintiff was using it. What they're trying to do here is they submit this motion, and they basically want, okay.
I understand there were two statements in the one document. The one the plaintiff used, and the other one they didn't. It depends on the circumstances and whether there may be cases where that entire thing was accepted. But both statements did not have to be accepted here.
I'm saying, Your Honor, what the plaintiff is attempting to do, though, is they want to have, okay, here's this one part of this motion that we're using as our entire basis for our prima facie case, merely to show, okay, yes, Countrywide received the bill. However, they want both the appellate term and this court to ignore that same proof that's in that motion.
That's exactly it. That proof isn't admissible. The proof isn't admissible. You didn't argue that I put in the business records to show the verification request. Your proof is inadmissible. Their proof is admissible because it's an admission against interest. Your proof, which is an exception to the hearsay rule, your proof, you didn't show anything that all of this was hearsay, but they put it in as an exception to the hearsay rule. You didn't. You could have said, this is a business record, my verification requests are business record, here's the affidavit that shows it, but you didn't make that argument. You said, I rest, I got nothing. So if your prior consistent statements are not exceptions to the hearsay rule on your case in chief. They're only admissible if there is a question that would render them admissible because there's a question as to whether or not you're changing your story. That's all I think what we're trying to say here. Do you see what I'm saying?
I do see that, but it's still, I would submit that this, whether or not part of this was admissible, part of it was not, it was still the plaintiff's obligation to show this bill was overdue, which it was not. All they showed by virtue of that motion is that the bill was received.
But
and not paid.
Your argument is not overdue because of the verification. That is your argument, but you'd have to preserve that. Was as my colleague said, it was never raised. It was never preserved, right, for us to consider.
I would submit that the burden never shifted to Countrywide to make that showing that the bill
In
was
your
overdue.
affidavit, you said we didn't pay it because we sent them verification requests that they didn't respond. That's an admission against your interest that you didn't pay, right?
Right, but again, I would go that there was still a plaintiff's prima facie burden to show that the bill was overdue, which they did not do by virtue of relying solely on this motion, as opposed to bringing in a live witness to testify to make out a prima facie case under Etienne.
Thank you.
Unless the court has any further questions, we'll rest on the arguments in our brief. Thank you.
Thank you.
Just real quick, it's not the appellant's burden to prove that whether or not there were verification requests. That's the respondent's burden. They didn't meet it. Thank you.
Thank you both. I don't know if I'll get this right, but Dietering? Dietering?
Yep.
Okay, all right. Versus New York City Environmental.
Good afternoon, Your Honor. Oh, that's a little loud. Good afternoon, Your Honors. Remy Green. For the transcript, I should appear in the transcript as Mix Green, spelled MX period rather than Mr. or Miss. For the the petitioner appellants. I want to do three things while I'm up here today. First, I just want to clarify something, kind of post-briefing. Second, I want to talk about retroactivity. And third, I'm going to talk about SECRA. So the first thing is I just want to clarify that in Dietering 2, this is the case we reference in our footnotes that's in the federal court. The city is now saying that this decision below covers not just what the court said, this is record 13, that legislation applies only to summons heard after the operative date. But now the city is taking the lower court's decision and saying it applies to all summonses, including those heard before the effective date. So I think at a minimum, we have to be looking at a remand so that the lower court can opine on whether applying this to summons heard before the effective date would be retroactive. Or the court should be very clear that the city can't rely on the case that way. They can't talk out of both sides of their mouth this way. With that, I want to talk about retroactivity. The clear rule in Regina is that applying legislation to either claims pending at the time that legislation is passed, that's page 364 of Regina, or if applied to pending cases, that's page 367, Regina couldn't be clearer, a law is retroactive. Retroactivity analysis has two steps. You determine if the law is retroactive, and then you analyze the means-end connection. The lower court didn't get to the means-end connection because it said the law wasn't retroactive at all. But that's just not right under Regina. Regina says that retroactivity exists where you're applying legislation to claims that are pending or cases that are pending. All the summons here were pending as of the date that the law became effective, right? That's the world. It's an Article 78 or a hybrid Article 78.
No, you have to have a property right, right? The fact that the case is pending doesn't. You're saying I am entitled to the old fee structure. The legislature is entitled to fix whatever it's going to fix in the middle of your lawsuit, and unless we can apply it to your lawsuit unless you have some property right that it would be affected by it.
I don't think I think that's blurring the taking case law and the retroactivity case law. I think, in fact, one of the, and I'm forgetting.
Well, let me start with then. What property right do you think you have?
I think they have the same as a lien. It's effectively a lien on the recovery. They act.
What about the fact that the city can say we're going to remit, no punishment?
That's fine. That is also true.
You don't really have any property right until the fine is decided and the money is paid, right? So while the action is pending, you don't have the right to anything.
I think there's an inchoate right.
An inchoate right.
I'm sorry, that may, there's a lien, effectively. I don't see it as being any different than a lien under Judiciary Law 485. Right? In those cases, a plaintiff could dismiss their case after a lawyer is terminated, but the lawyer doesn't lose the case simply because the plaintiff could dismiss it. They don't lose their lien. It's a contingent lien, but it absolutely exists. It is a property right in the relevant sense, and it's no different here. With that, I also want to move on to secret because I do want to make sure to get that addressed. I think that the city's arguments here, or DEP's arguments, are inconsistent, and they can't have it both ways. Either this is a massive regime change, and that's important, and that's what they were trying to accomplish, which is the goal that they're allowed to with retroactivity, or it did nothing, and therefore there's no major reordering. DEP identifies two bases to say that no review was required. The first I don't think makes any sense. They say this is an enforcement proceeding. SECRA applies to all government actions. This is not an enforcement proceeding, it's a legislative enactment. all that provision is saying is that when the government sues to enforce a law, it doesn't have to conduct conduct an impact analysis. There's nothing about this that's nonsensical. The second is that they are allowed to, when you change fee structures, et cetera, you don't have to conduct review unless it's a major reordering of priorities. The ordering of priorities before this law was quite simply, we want to encourage enforcement at all costs. Everybody please enforce. And then by the lower court's own reckoning, right, this was designed to disincentivize enforcement. It is a 180-degree shift in enforcement priorities. If this is not a major reordering of enforcement priorities, nothing is. I mean, you know, we can look at the record on the law. Record 1395 put a stop to this enforcement. Record 395 put an end to this enforcement. Record 240 reduced the volume of summons. And again, the lower court's own words about it. This is intended to disincentivize certain enforcement. It's a major reordering of priorities.
Thank you. You have rebuttal time.
Good afternoon, Your Honors, and may it please the Court. Amy McKenfield on behalf of the respondents. Your Honors, I want to clarify that the only oath cases that issue here by petitioners' own clarification in their briefs are the cases for which summons had been issued, but no hearing had yet been held at the time that Local Law 16 was enacted. Now, petitioners are seeking to split their claims. They have a federal case pending in district court where they're challenging cases later in the pipeline where hearings had been held. Those are not at issue here. And in this case, it's particularly easy to see that all of petitioners' retroactivity arguments all fall flat. First of all, they don't have a protectable interest. And second of all, even if you look at the claims on the merits, they all fail. With respect to the protectable interest, the federal key Tom cases are very analogous and directly on point because they show time and again in the Federal Circuit case, Brooks v. Dunlop, in the Second Circuit case, Rodriguez, courts hold time and again that legislatures can amend key Tom statutes, even if those amendments remove a key Tom relator's right to pursue a pending case, and that doesn't implicate any constitutional rights.
What happened to petitioners' claims based on substantial evidence as to some of the cases that had already been a hearing had been held?
That's a good question, Your Honor. I believe that petitioners had indicated they intended to perfect that appeal, and they never did. So I
They
don't.
filed a notice of appeal with respect to those, some that they disagreed with, and they say that it wasn't supported by substantial evidence, right? But I didn't see any argument on appeal with respect to that.
No, that appeal has never been perfected.
Okay.
And the time to do so has passed. So what we have here is a facial challenge to the constitutionality of Local Law 16, very high bar to show. And again, the key Tom cases directly on point. Petitioners misinterpret our key Tom reference as a standing argument. It's not about standing. We've never argued they don't have standing to bring noise code cases or that they don't have standing to bring this case. What those key Tom cases show is that you don't have a protectable interest to challenge legislation that takes away your right to your ability to pursue these kind of claims. Second, even if you look at their constitutional claims by the applicable standards that apply to those claims, they still fall flat. So I'll focus on the Due Process Clause claim because that's what plaintiffs focus on here. First of all, Local Law 16, not retroactive in the first place. It only applies prospectively. The Administrative Code says that citizen enforcers can recover out of the proceeds collected. Local Law 16 only applies to cases where proceeds hadn't been collected yet. Even if it was considered retroactive, which it shouldn't be, there was a rational basis for that. For the retroactivity, you could argue, you could view it as, and the rational basis was the legislature wanted to address cases in the pipeline because they saw that there was this 2-year period when there was a lot of these cases that were really burdening local businesses, and they wanted to remove the incentive for the citizen complainants to continue to prosecute those cases. It was a short period of retroactivity, and under Regina, when you have a reason for retroactivity and it's a limited time period, that withstands constitutional review. So even the cases that petitioners are seeking to rely on, they don't help them. Also, with respect to the point of whether it's retroactive in the first place, Regina says propriety of prospective relief, cases that legislation that amends that, not retroactive. So again, their cases don't even support them. With respect to the secret cause of action, Local Law 16 was not subject to environmental review. There's 2 different type 2 categories that apply here. With respect to the first one, it's this local law 16 qualifies as the adoption of policies and procedures that pertain to enforcement proceedings. It also qualifies as routine administration and management. And as we pointed out in our brief, the penalty schedule has been amended many times over the years with no indication that environmental review is ever performed, because this is the same kind of routine management decision and change in policy and procedures relating to enforcement proceedings that does not require environmental review because it explicitly falls within the type 2 categories.
Did the city council need to make an explicit finding that's a type 2 action? Did they need to make an explicit finding of that?
It does not, Your Honor, and once something qualifies as a type 2 action, there's no need to even note that, because, again, it doesn't qualify for environmental review. So there's no need for it to explicitly say so once it falls in the type 2 category. So again, for all these reasons, petitioner's claims all fall flat. This case was correctly denied by the Supreme Court. And unless this court has any further questions, we would rest on our brief. Thank you.
Let me pick up with the housekeeping. The substantial evidence issue we're not here to talk about today, and I think the time has expired.
So you agree that those cases, that's abandoned?
Yes. So let me first say, this is not a facial challenge. This is an as-applied challenge. Because it's in a hybrid Article 78, I think it actually has to be as-applied. Otherwise, it would be a fully plenary action. So no, this is not facial, and it doesn't face the standards of a facial challenge. One thing my friend on the other side said that was very interesting is I think that the goal of the legislature here was to remove the incentive, right? Remove the incentive entirely that's existed for half a century for citizens and environmental groups to enforce this law. That, I think they would agree, the incentive doesn't exist anymore. It is not only below minimum wage, it's cents, if not fractions of a cent per hour of work. But
you don't have any vested right or vested, interest in this statute. I mean, that's, you don't have a...
It is, I don't think key TAM actions are a good analogy, and I think that they're drawing that in part from key TAM cases. This is no different from a lien. And again, all the cases about, say, judiciary law liens say, no, that's not inchoate. No, that is a property right. A lien on a case.
How do you get a lien? How do you?
It's no different than an attorney working on a file and having some right to be paid for their work.
But the thing is, what is your right to get paid for?
Their right is what the statute says. It explicitly, and this is a big difference, I think, between the key TAM actions, it promises compensation. That's literally the word.
But that would mean a contract, as if you had a contract.
Right.
You said it's the same thing as if it's an attorney, but there's a contract there. You don't have any
But you
contract to is unilateral right to this?
In fact, it is exactly that. It is an offer that can be accepted by performance in the law.
But then how do you resolve the fact that the city can say, I'm going to no remittal, no nothing, you get nothing, if the city can continually just say, no fine? So you don't have any right to no, if you're saying my right is to no fine.
Right, I mean, I think that is exactly the answer. If they do that, they're okay to do that. But that's not what they're doing. They're collecting the money and keeping all the money. That's why it's a taking. That's the property right that's being invaded. If they wanted to do it case by case, they could do it. But that's not what they're doing.
Thank you. Thank you both. Okay, we're going to go back to number 2, which is O'Brien versus Tectonic, and Justice O'Neill Levy is recused from these cases. Actually, I need to do one case before because, oh, no, that's it. Never mind. I just wanted to make sure. Yeah, no, she has. Is looking down. I need to keep my glasses on. Okay, go ahead.
Good afternoon. May it please the court, I'm Steve Arapach from Birdsey Ryback for plaintiff. It's now agreed between the parties that the order appealed from was incorrect as to the reason the judge gave for denying our motion for summary judgment under 241-6, because he chose his own issue and said that a worker heading to the bathroom at a construction site may not be in the guise of a construction worker. It's agreed that that is an improper thing. So that brings us to the actual merits of the Rule 23 violations that we're talking about. First,
So it's
23-
your position that under 23-1.7E1 and E2, the ramp was a passageway, and it was
working area.
and it was a work area. What about 1.7F?
With 1.7F, the defendant's cases concerned height differentials that were up to 15 inches tall. This was up to 16 inches tall. So that's a distinguishing
In other
thing
words,
the
is
first
it,
But-
given the cases and the fact that it is this 12 to 16, and I think, or 12 to 15, yours is 12 to 16, I think, is that sufficient to fall under 1.7F?
That was the reason I used to avoid summary judgment under, although they didn't move for it. But I think that what gets us, or what should get us to summary judgment on this rule is the fact that a ramp was provided and it was defective. So since they provided a ramp that did provide access to a higher level of up to 16 inches, it should have been safe, and therefore it did not comply with 1.7F.
Thank you.
Do you have any other questions? I mean,
No,
okay.
thank you.
Good afternoon, Your Honors. John Nicolini for the defendant respondents. Your Honor, just picking up, I think, with 1.7F, it's our contention that it's not applicable because the height differential is exactly what the court has previously concluded. It does not require a ramp. And that section envisions accidents that occur due to a lack of a ramp. That's not the situation here. The ramp was initially put in place to accommodate heavy machinery. He chose to use it as a pedestrian ramp, and even
It wasn't just him, right? I mean,
Yeah.
it was all the workers were,
Correct.
because if they didn't want to jump up, and there was a desk, I looked at the pictures, sort of blocking the way, this was another way to get to the bathroom.
You're right, Your Honor. It was there were numerous ways to get there, including just simply stepping up onto it. He chose to go this route. It wasn't clear whether all the workers did it or just him, but he chose to utilize it as a pedestrian ramp. But 1.7F applies to accidents which occur due to the absence of a ramp. It doesn't talk about the ramp being improper or dangerous. It's the absence. This did not occur due to the absence of a ramp. He's claiming it's a passageway, and we address those issues under the 1.7E1 and 2. And just very briefly, it's our contention that you can't say it's a passageway and then say it's an encumbrance or it's debris that's blocking a working area. You can't have both. If it is in fact a passageway I'll concede it was a passageway by virtue of the fact that he chose to use it as such. I'd also submit
You
that
keep saying he, but there's nothing here that says that it wasn't, that he put it there. The workers put it there, but they used it, the testimony is, to get to the bathroom. And so it was a passageway within the meaning of 1.7 E1.
Conceded, Your Honor. And our position, once it was conceded it was a passageway, as all the cases that the courts have decided deal with encumbrances on the passageway itself, debris and materials and whatnot. They don't talk about if there's a height differential which constitutes the passageway itself. You can't trip over the structure that forms the passageway and then claim sub 1 was violated. It doesn't apply to, I'll just give an example. A staircase could certainly be a passageway, and if a worker simply doesn't lift his foot up the 8 inches the tread height should be and he trips over it, you can't say 1 was violated because
Yeah,
there was
but
a height
this
differential.
wasn't simply a passageway that was working in the way it was out of, it had been damaged, and so it was raised beyond that point where he would have lifted his foot up. I don't think we can
Well, Judge, if it's a passageway, and that's where I think it's a problem for him to rely upon both sections, because if you want to say it's a passageway, I stand by the argument that every case he cited to and every case that I found talks about once you're on the surface of the passageway, is there something on the surface which should not have been there? This is not that. He tripped on the passageway, the structure itself. If you want to say, well, it was collapsed, and therefore it was no longer a functioning passageway, then you're into two, which talks about encumbrances or
Well, why couldn't this be under one, a condition which could cause tripping? That's what one says. It's not just debris, it's a condition. Isn't this a condition that can cause tripping? Industrial Code 2317E says, passageways shall be free from accumulations of dirt and debris and from any other obstructions or conditions which could cause tripping. And that's what he's arguing. This, because of the way it was messed up, it was a condition that caused his tripping. Why is that not applicable?
And I would return, Your Honor, to every case I've seen and every case that's
Oh, I mean,
cited, and I
yes, but
understand,
there's
Your Honor.
always,
No,
we
I
can't.
understand. But and I would come back to, we have a physical structure that we're agreeing here in this argument constitutes a passageway, and we have an individual who tripped over the physical structure itself. So whether the height differential is due to the fact that it just simply existed by virtue of its construction or it's in its collapsed condition.
But the height differential is, different. Whatever the ramp was, whatever that bit was not what caused him to fall. It was the fact that it was broken, let's say. It was damaged because of this, whatever was on it, and that put it into a condition that caused him to trip.
And I would submit, if the court is going to go there, it would be a departure from the cases where and I would stress that I really feel, and I've advocated.
Well, do you have an explanation for what condition is?
I can see condition is a very broad term and refers, but I would also push back on condition. Would that also open up the door to, if a tread height is 8.5 inches as opposed to 6 inches, that's a condition, and therefore it's not
But
a
we
safe
don't have to
passageway.
use that. We're talking about these.
Understood. And just very briefly, Your Honor, just the second part of the argument is proximate cause. That was our position, that if in fact the court determines that there's a violation of the industrial code sections alleged, there also should be an opportunity at trial for us as defendants to advocate that plaintiff was the sole proximate cause. The cases relied upon by counsel are all 240 cases. It's a different standard under 241 sub 6. It's what a reasonable juror construing
This
this
is a
evidence.
240, it's still within, that would still be a comparative negligence issue, wouldn't it?
Oh, 100%, but what this does is, at trial, it handcuffs me to argue to the jury that you can find the plaintiff 99% responsible as opposed to 100%.
But comparative negligence doesn't defeat 241-6.
But sole proximate cause does. And if the
sole proximate cause is really a comparative negligence.
But the charge at trial to the jury would be not only, ladies and gentlemen, do you have to determine.
We're not dealing with a charge at trial here.
No, but the court's determination here will determine what the trial judge is permitted to do.
And my answer to you is that it really is not a sole proximate cause issue. This is if you're saying, I think what you're really saying is a comparative negligence issue.
No, I'm saying it's a sole proximate cause issue to the extent that this gentleman had other options available to him. He need not have utilized this to access the bathroom. He chose to do so. And in so doing, he knew the condition and used it for days beforehand in the damaged condition. He chose to do that when he had other options available. And when he chose this option, he simply didn't lift his foot sufficient to traverse the area. And I would just very briefly.
Counsel, your time is up.
Okay.
So we've already gone over this with the condition and.
Yeah, I understand.
Thank you.
Thank you for your time, Your Honors.
Counsel, can I ask you a question about, there are 3 sections of the industrial code that we've been talking about. There's 23-1.7E1 and E2, and there's also 23-1.7F, right? Now, it seems to me that as to 1.7F, that was part of a motion that you made to amend your complaint to add that section. That was granted without opposition, correct?
I believe that what I moved to add was 1.7E1, and the others were already alleged. And yes, amendment was granted without opposition.
Counsel, what do you say to the counsel's argument that he should be able to argue that the jury, that your client was the sole proximate cause of the injury because he chose to go up to the wrecked ramp?
Well, as I argued on this appeal, the sole proximate cause defense, as set out by the Court of Appeals in Cahill and Gallagher, requires that it doesn't apply just if, hey, there was a safer way and plaintiff chose a way that didn't work out. They have to show that plaintiff disobeyed an instruction not to do what he did.
Right. I mean,
They don't
that's
even
what that
allege
defense
such an
is. I've never, right. So so what you're saying is it could be he's 99% liable because of whatever, comparative negligence, but sole proximate cause doesn't apply here.
Does not apply. And the defendant inaccurately states that I haven't cited any cases where the tripping hazard was part of the building itself. The Kaufman case of this court, the plaintiff was pushing a cart up a ramp. It hit the door saddle in the doorway, and that caused that essentially tripped the cart and caused it to fall on a plaintiff. This court granted summary judgment to plaintiff under both sections, 23-1.7E1 and 2, finding that the doorway was clearly a passageway, but also it was a work area because it was a place where people work or pass. And also, defendants claim that it was an integral part of the work. If the ramp itself may have been an integral part of the work, but the defective...
The ramp here wasn't repaired in any case.
Right, the 2 to 3 inch gap at the bottom was a tripping hazard.
Thank you.
Thank you.
Madame versus AECOM.
May it please the court, my name is Milton Williams, Walden, Mock, Herron, and Williams representing the appellant, Jay Badami, in this matter. So, Your Honors, this case factually, before we even reach Don Kenny, Waldron, Hayes, and Frommer case, this case is factually demonstrates that the defendant early on eliminated any applicability of the old employment contract. The CEO of the company sent a letter to Mr. Badami stating that he was now an at-will employee and specifically incorporating by reference an RSU agreement, restrictive stock unit agreement, which had an arbitration clause, which did not have anything about discrimination or discrimination or whistleblower claims in it at all. And so the letter from the CEO specifically incorporated by reference the RSU agreement with no reference to the old employment contract. And the president of the company followed up with a letter to Mr. Badami stating that he was demoted and again incorporating the CEO's letter and the RSU agreement. These letters were carefully drafted and clearly demonstrate that the old employment contract with the arbitration clause that the respondent is arguing is applicable, those letters demonstrate that they're no longer applicable. Mr. Badami was president of the company at that time, and now he was demoted to another position. Now, once you get past the facts that I just cited, if you look at this department's rulings with regard to arbitration clauses, Don Kenny, Waldron, Fromer, and Hayes clearly demonstrate that an expired employment, the arbitration provision in an expired employment agreement does not renew unless there is a clearly expressed intention to do so. And that does not exist here at all. There's nothing. In fact, there's the opposite of a clearly expressed intention to do so, as demonstrated by the letters of the CEO and the president of the company to Mr. Badami. Even assuming, if you were to accept for a moment, and I'm not conceding anything, but if you were to accept for a moment that the arbitration clause, for whatever reason, did survive, and that there, as respondent argues, the facts here relate back and relate back and arise out of the employment. Sorry.
I'm afraid I'll forget. What about the survival clause in section 5.09 of the contract? Wasn't that intended to survive post-termination obligations and include the arbitration that was in the contract?
I would agree with you, except, Your Honor, the letters from the CEO and the president clearly demonstrate that the old employment contract is not applicable under these circumstances. I'd also point out that the crux of the claims that Mr. Badami is making all occurred after the expiration of the employment agreement. And so those claims are not governed by the old employment agreement. And the respondent's argument that there were claims or there were conduct by the respondent that we allege in the complaint, that they have some applicability now, the claims pre-expiration of the contract and the claims post-expiration of the contract are inextricably intertwined. And so under ALP and other cases, clearly the court is the court, as opposed to arbitration, is the proper forum for that. I'll stop there.
Good afternoon, Your Honors. May it please the court, Brian Kaplan, DLA Piper for Respondent ACOM. Your Honor, there's a lot that's undisputed here, but I'm just going to cut to it. This is a really straightforward application of this court's precedent and the Court of Appeals precedent. The parties entered into a valid arbitration agreement. The parties delegated all questions about arbitrability to the arbitrators. The cases that are cited by my colleague are just not applicable. This is not a situation in which you've got two competing rounds of cases. The cases all line up together. These cases, Waldron and the like, are when there's no contract. A contract was...
What about, I mean, some of these issues that they wanted to litigate or arbitrate or have dealt with by somebody were post-termination situations. And that's why I asked your friend here about section 5.09, the survivor clause of the contract. Yeah. So I'll ask you the same thing.
Yeah, exactly, Judge Kapnick. So there's a few different reasons why. I mean, your comment is right on, and it just also shows why those cases aren't applicable. In those cases, a contract was rejected. The parties literally said, we have no more contract. In the other cases, the party said at the beginning, we only have a contract for this term, and then if we don't specifically renew in writing, the contract goes away. That's not what we have here. We have actually the opposite, plus the survival. We have a situation where there's a contract that actually says there's an initial term, and then after the initial term, you continue to be employed at will. And there's a whole bunch of provisions that still apply after that initial term. The idea that this contract expired is a fallacy. That's not actually what happened here. Even if we were to assume for a moment that the contract expired, which it didn't, just the initial term did, there's an entire body of case law all the way up to the Court of Appeals in Primex that says the presumption's exactly opposite from what my colleague's saying. Under precedent since the 90s at least, the party's arbitration provision is presumed to continue even after expiration, absent a clear manifestation of contrary intent. These letters, nowhere in these letters do they say, we are not agreeing to arbitrate. That's a clear manifestation of contrary intent. And as this court explained in Remco, if you've got a broad arbitration clause like here, an arbitration clause survives, kind of period, full stop. Even if we didn't want to get there, Your Honor, because the parties, Your Honors, because the parties here decided to incorporate the AAA rules, this court in Moby Richard, Life Receivables, Anema, WN Partners, all the cases cited in our briefs, say that when you incorporate the AAA rules into an agreement, it's clear and unmistakable evidence and conclusive evidence that all these questions we're talking about get delegated to the arbitrators. So it's the arbitrators to decide precisely what the survival clause means, precisely whether there was, whether there was something that should be addressed here. A few really quick points, Your Honors, and unless there's other questions. The idea that some claims were not during the initial term, some claims were. The complaint is talking about how alleged discrimination and retaliation, because of that, there was a specific reference to not renewing this employment agreement. The employment agreement's, purported evidence of retaliation. The employment agreement has an arbitration provision, and all of these issues go directly to the arbitrator. So this really is an open and shut matter. And if there are no further questions, I'll rest on our briefs.
Thank you.
Thank you, Your Honors.
Your Honor, with regard to your question about survivability, Judge Kapnick and my learned colleagues' points, Primex is an entirely different matter. It doesn't involve an employment contract. Primex and Remco are the two cases that respondent relies most on, and in Primex held that an arbitration clause will generally survive a contract's termination. But unlike Waldron, Don Kenny, Hayes, and Primex, it does not involve an employment contract, let alone an employment contract where it had expired. Now, clearly, employment contract here had expired, which is why the president and CEO sent letters to Mr. Badami, to the appellant. And the fact that they sent letters and the fact that they demoted him, how could the survivability clause, how could the prior contract apply when he was in an entirely different position? If he was in the same position, their argument might have more weight. But he was not in the same position. They changed his position, and at that point, the old employment contract had no applicability. And the fact that they drafted letters and incorporated by reference another document, the RSU document, without specifically even referencing the old employment contract, really illustrates that point. I'd also point out, that the conduct post-employment contract, post the expiration date of the employment contract, all in the May, July, and August of 2023, where he was demoted, where he was removed from a project, and where he was terminated, all occurred well after the expiration of the employment contract. And therefore, that type of conduct, which is the crux of the case here, is not under the auspices of the employment contract. He had a different position, and therefore the old employment contract has no applicability. I'll stop there.
Thank you. Thank you both.